Back on the record in the case of Region 10 PIHP and others against the state of Michigan and others. This is docket number 25-000143-MB. This morning, we heard extensive arguments on, I guess, what are essentially competing motions for summary disposition because the defendants moved under C8 and C10. And then the plaintiffs sought relief under 2.116I2. So I think we've finished up with that portion. We're moving on now to the plaintiff's ex parte August 28th, 2025 motion for expedited consideration and the plaintiff's motion for a preliminary injunction. I'll just say briefly that I have in effect granted the ex parte motion for expedited consideration because we are here on a very compressed schedule. So I'm going to, at this point, deny that motion is moot if I haven't ruled on it. And then we're going to go to the injunction motion itself. I just want to set the table here by reading briefly from a Court of Appeals opinion that I think lays out the law in this area very well. It's Davis against Detroit Financial Review Team, 296 Mishap 568, beginning at 613. And then carrying on for a few pages after that, which I'll identify. Here's what the Court of Appeals has said about injunctive relief. Quote, an injunction represents an extraordinary and drastic use of judicial power that should be employed sparingly and only with full conviction of its urgent necessity. This court has identified 4 factors to consider in determining whether to grant a preliminary injunction. 1, the likelihood that the party seeking the injunction will prevail on the merits. 2, the danger that the party seeking the injunction will suffer irreparable harm if injunction is not issued. 3, the risk that the party seeking the injunction would be harmed more by the absence of an injunction than the opposing party would be by the granting of the relief. And 4, the harm to the public interest if the injunction is issued. Continuing now, the court in Davis, 296 Mishap at 614 made this interesting observation, which has become something of a concern to me now that I'm on the Court of Claims. Quote, the Supreme Court has recently recognized that declaratory relief normally will suffice to induce the legislative and executive branches, the principal members of which have taken oaths of fealty to the Constitution identical to that taken by the judiciary, to conform their actions to constitutional requirements or confine them within constitutional limits. Only when declaratory relief has failed should the courts even begin to consider additional forms of relief in these situations. Similarly, when we're talking about governmental officials, Davis said at 296 Mishap at 621, quote, case law also recognizes that when the record fails to indicate that a public body has acted in bad faith, there is no real or imminent danger of irreparable injury requiring issuance of an injunction. Now, having said that and talked about how careful I should be about issuing injunctions against public officials, I do want to assure you, Mr. Marchand, that my intention here is to get a decision out simultaneously on the injunction and declaratory relief summary disposition motion. So I trust that if the decision goes against the defendants, that declaratory relief will be sufficient. If it isn't, you can let me know immediately, and then I'll have to do something in terms of an injunction instead. But I'm going to go ahead and consider it today. So if I need to make those findings later on, I'll be in a position to do that. Okay?
Thank you, Your Honor.
All right. Now, let me get all of the attorneys who will be participating in this hearing to put their appearances on the record because our court reporter is remote and I want to be fair to him in allowing him to understand who's on their feet at any given moment. So Mr. Marchand, why don't we start at your table? I only need you to introduce yourself and anyone else who is going to be participating actively in this hearing.
Thank you, Your Honor. Neil Marchand for plaintiffs, Chris Ryan for plaintiffs, Sarah Wixom for plaintiffs, and Aaron Lake for plaintiffs.
All right. Thank you very much. Now, let's see, Ms. Service, I see that you're now sitting in the dugout, so I take it some of your colleagues will be taking the lead. Why don't you go ahead and introduce yourselves? If somebody's going to be playing an active role, please put your appearance on the record this afternoon.
Judge, so I can introduce, Judge, Brian Beach, from the General Docs on behalf of the state defendant, alongside Damage and Tyler Kinsmiller, taking their hearing, possible to set these items.
Very well. Okay, it's going to be an active afternoon. Why don't we do this? Mr. Marchand, we talked before we went on the record and we said we dispense with opening statements before we begin this evidentiary portion. Why don't I let you go ahead and call your first witness and we'll proceed in that fashion, and then that'll afford everybody much more time to make arguments after we have the evidence closed.
Your Honor, in terms of housekeeping, all of the attachments to the pleading are also being considered.
Yes.
I don't know if that was on or off. I lost track.
Yeah, as far as the evidentiary record goes, I said I'm not going to be a stickler on foundation, and to the extent that anything was attached to papers, I'll be glad to consider it.
Thank you, Your Honor. It's called Jeffrey Patton.
Very well. Come on up, please, sir. From where you are, it's a bit of a trek. Come on over.
He'll swear you in.
Please raise your right hand, sir. You solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth? Thank you very much. Please have a seat. Make yourself as comfortable as you can be in that makeshift witness box there. And if you don't mind, please tell us your first and last names and spell your first and last names for the court reporter.
Thank you. My name is Jeffrey Patton, Jeffrey, Patton, Patton.
Thank you very much, Mr. Patton. And whenever you're ready, Mr. Marchand, you may proceed.
Thank you, Your Honor. Mr. Patton, could you tell you, are you presently employed?
Yes,
Where are you employed?
I'm a Chief Executive Officer of Integrated Services of Kalamazoo, which is the Community Mental Health Authority for Kalamazoo County.
How long have you been the CEO of Kalamazoo ISK?
Actually, I just finished up 24 years.
Where were you employed prior to Kalamazoo ISK?
Mission Department at the time, Mission Department of Community Health, which is now the Michigan Department of Health and Human Services.
And what was your role at the department?
I had many roles with the department, but my last role was Deputy Director for Mental Health and Substance Abuse Administration.
And how long have you worked in Michigan's public behavioral health system?
Many, many years. I believe that I was director of Pheasant Ridge Center, which is a psychiatric hospital for children. And I believe that was in 1984 and through 2001 with the mission, with the state.
Okay, so you worked approximately 17 years for the state and then another 24
years.
As a
community mental
local
health.
CMHSP.
Yep.
I'd like to talk about, given your decades of experience, I'd like to talk about the context of Michigan's public behavioral health system in the 90s to the early 2000s. Okay. Can you describe what was happening in the 1990s relating to specialty behavioral health services?
What was happening in the 90s were happening throughout the country, where states were entering into managed care arrangements with various federal waivers to provide mental health and substance use disorder services. What made Michigan extremely unique is that it combined those services with persons with intellectual and developmental disabilities. I believe it was the first and perhaps the only state to have combined those waiver authorities.
Who served as the prepaid inpatient health plans under that Medicaid framework?
What period?
During the 90s to up until 2000.
Yeah, actually in 1998 was the first waiver, was a combined waiver. 1915 BC waiver
Okay.
was approved by the Healthcare Financing Administration, and all 49 community mental health services programs were designated by the state as prepaid health plans at that time.
And tell me how things progressed from there, from 98 to 2000.
Well, there were conditions that were placed on that first waiver in 1998. The federal government, which was HICFA, Healthcare Financing Administration, which is Centers for Medicare and Medicaid Services, there was a requirement that the state would have a full and open procurement, which would include both the private sector and the public sector. Michigan asked to waive that condition for the first 2 years of that waiver period. And the second waiver period, the state had to come up with a plan to enter into full and open competitive procurement.
And did you work on that plan?
Yes, I did.
Tell us about it.
Well, the first plan, I was with a team at the department. I was not deputy director at that point in time. We worked with the feds to actually present and to get approved the first 1915B combined waiver authority. And then moving to the second period, and we knew very well that we had to open the system up for full and open competitive procurement, which would have permitted the private sector as well as the public sector to bid equally. And we made the argument that that was not in the best interest of consumers in Michigan and the best interest of the state of Michigan. And we received approval to not open that up for full and open procurement.
And is that approval the 2001 approval from the Healthcare Financing Administration?
Healthcare Finance Administrator, yes.
And when you say you worked on the revised plan for procurement, if you open that book, is that Exhibit 1 in the book? Is that the revised plan for procurement that you worked on?
Yes, it is. In fact, it has my name on it.
What a coincidence. Now, so if I was understanding you, in 98, the state asked for authorization to continue with a sole source procurement through the CMHs, right?
That's correct.
And then in 2000, you worked on this revised plan for procurement, correct?
That's correct.
And did you, in the revised plan for procurement, what was the state's conclusion again?
The state's conclusion was that it was in the best interest of the state to maintain the sole source contractual arrangement with the public community mental health system.
And you said CMS approved that.
That's
What is
correct.
now CMS?
Yes.
And to your knowledge, has that plan for procurement ever been changed?
You can object. I don't know. I think he testified last work 24 years ago, so I don't know that you would acknowledge that.
Well,
You want to try to lay a little foundation? Because I'm happy to take the answer if he has a basis to know.
have you worked in the public behavioral health system since 2001?
Yes.
Are you familiar with the waivers and requirements under which you have to serve as the CEO of Kalamazoo Integrated
Yes.
ISK?
Yes.
Do you keep up with the state's submissions to CMS?
I do to some extent, not the way that I used to in the past, but yes.
Are you aware of, have you kept up with the state's procurement submissions?
Yes.
And are you aware of any change to the revised plan for procurement from September of 2000?
Yes, the most recent one that was issued does not, it does not open it up for full and open competitive procurement.
What does it do?
What it does, it provides various restrictions on how organizations are formed or organizations are organized to be able to bid on the procurement.
And do those restrictions go to what? Are CMHSPs eligible?
No,
Are regional entities eligible?
no.
Who are eligible?
Nonprofit organizations, hospitals, universities, and municipal organizations, which might include public sector entities.
And is this the state's current RFP?
That's my understanding, yes.
Has, to your knowledge, is there any, has the state submitted a revised plan of procurement to CMS to expand the eligibles?
I have no knowledge of that.
And he answered the question.
Yeah, that's okay. He said he didn't know,
Yep.
so that's fine. I don't need to rule on the objection.
Yep.
He
So-
admitted himself, no foundation.
Yeah. I want to talk about 109F for MCL 400.109.
Social Welfare Act?
The Social Welfare Act, yes. So 98, you had the authorization from the federal government to continue with sole source procurement, 1998.
Correct.
2000, the legislature passed MCL 400.109F, right?
Correct.
you were at the department at the time, correct?
Yes.
What was your role?
On my role, I was the deputy director at that point in time of mental health and substance abuse services. We worked with Senator Beverly Hammerstrom to actually introduce that legislation.
And tell me more about that.
Well, we thought that at that time that we need more enabling legislation to move forward with the sole source contracting with the public system, the public community mental health system specifically. And we thought that we should have amended, and we did get amendment to the Social Welfare Act to include prepaid health plans.
Okay. And why did you think you should do that?
Well, we thought that we needed that enabling legislation to just maintain that sole source contractual relationship. And we worked very closely with Senator Hammerstrom to make sure that it was in there. We thought that the time limitations of doing that and trying to get the mental health code amended to have language in there, we didn't think we had enough time. So we chose the route of the Social Welfare Act.
And so that was end of 2000, if I recall correctly, right?
Yes, I believe so.
And you left the department before or after the federal government authorized sole source procurement in the February 2001?
For the 2001, I left the department after approval. I received their approval from the Healthcare Financing Administration, directly received the approval letter.
Okay. And then you went to Kalamazoo ISK?
I went to Kalamazoo ISK in October 1, 2001.
How was the public mental health system set up at that time in terms of a model?
It was interesting. It was interesting leaving the department where we actually had put the revised plan of procurement together, and we actually published that, and we promoted that throughout the state. We had numerous town hall meetings, but it was a real change to be on the other side of it. And being the director of a community mental health services program that had to apply with the application for participation to be on that end of things, and it was quite different.
And did Kalamazoo apply?
Yes.
And were you selected as a prepaid inpatient health plan?
Yes, Kalamazoo was selected as a prepaid. At that time, though, it changed from prepaid health plan to prepaid inpatient health plan. We were what was called the hub, or the PIHP for a 4-county region. And in addition to that, we were also designated as a substance abuse coordinating agency for 7 counties.
And was Kalamazoo given a first opportunity to apply before any other private entities?
Yes.
And was that in accordance with the revised plan for procurement that?
Yes.
Yep. Were you involved in another application for procurement between 2012 and 2014?
Yes.
And can you tell me about that?
When the department urged urged and worked with the system to develop 10 regions, which was quite interesting because 7 of those regions we had to form regional entities in accordance with 1204B of the mental health code, and then 3 counties remained the hub and spoke, or put it in other words, they were able to maintain their status as both a PIHP and a community mental health services program. That was Oakland, Macomb, and Wayne counties.
Now, you said the department urged the regions. Were the existing CMHs and PIHPs given the first chance?
Oh, absolutely. Yes.
And was that in compliance with the revised plan for procurement?
Yes.
And the federal government's
Yes.
authorization?
To my knowledge, yes. I don't think there was any opposition or at that time, I left the department. I don't have any knowledge what CMS approval was, but I assume it was approved because it's been in place to this day.
Now, I'd like to talk about the current request for proposal. Are you familiar with that?
Yes, I am.
And tell me, what regional entity are you a part of now?
Southwest Michigan Southwest Michigan Behavioral Health Regional Entity, which is Region 4.
Okay. Now, was Kalamazoo ISK given the same first opportunity to be a PIHP under this current request for proposal?
Under this current?
Yeah.
No,
Was Southwest Michigan Behavioral Health given an opportunity, the first opportunity to be the prepaid inpatient health plan?
not to my knowledge.
And so what's different now?
Well, I think the difference now, and I think the best way I can,
And I don't think it's looking for people, I as an expert. I haven't heard any foundation.
Yeah, I think I'll sustain that, but if you ask a more precise question, I think we can probably get there. That struck me as a vague and open-ended question. I'm not being critical. I'm just saying you can get there with a little bit more precision.
All right. So based on your experience, what has been your experience of the current RFP when compared to the 2002 and 2013 applications for participation?
well, let me just back up with the revised plan for procurement and the basis of it. We felt, and I felt the team, my team, and worked very closely with the team. We felt passionately that we had this direct, what we call this co-relationship and by contractual relationship with the Michigan Department of Health and Human Services. And that was for many years in place, even before Medicaid was, managed care was in place. We had this very close relationship. In fact, we talked about it in the revised plan for procurement. And that was satisfied by the whole system, that there was this co-relationship between the state and the county-based community mental health system. We shared many things for many, many years. And to this day, we felt that we should maintain that relationship. And it was a unique relationship, a relationship based on various funding streams. There was a time in the distant past where most of community mental health funding was state general funds appropriated. Then when managed care pretty much replaced or added on to the funding of community mental health services programs, individuals that are served in a system, they go on and off the rolls of Medicaid. And so someone has to pick up those services. You just can't just allow a person to go without services because of their inability to pay. And that's part of the mental health code. And we're required to do that. So we had that relationship with the department to work very, very closely with the department's plans. When we made many, many visits and town hall meetings throughout the state, there was first a plan for procurement before the revised plan for procurement. The plan for procurement was to bid the system out and to permit the private sector to bid. Through many, many town hall meetings throughout the state, and I was part of those town hall meetings, there was a lot of pushback from advocates, from consumers, from county officials. They wanted to maintain the public community mental health system. So that's why we actually revised the plan and did not open and received approval to not open the system up for full competitive bidding. But again, I began to your question, if I can finish my question.
Just saying, right.
Just a narrative. If Mr. Marchand got a question, though, I think we're getting a little bit off of what the question was different experience now.
Okay, why don't you go ahead and ask another question, Mr. Marchand, and Mr. Patton will go ahead and pick it up.
Is there anything else you'd like to say, Mr. Patton?
I'm getting
I know.
This is another hearing, and I think we let it go, but that was going on. I think we were headed into other topics. And
yeah, that's okay.
Maybe a little bit of opinion.
So I'll ask it this way. So in the past, you did a bunch of town halls.
Yes.
What has been your experience about the current process?
No town halls. Very little communication in terms of what the plans were, and certainly no participation by the system to work with the department in those plans. I do want to say, and I want to add to that, we have no objections to changes in the system, none at all. But our experience has been, I think to answer your question, our experience has been that we worked very, very closely with the department, even when I was at the department, with the public community health, with the public community mental health system, and also advocates of the state and other stakeholders to make substantive changes and particular changes of this sort.
Thank you, Mr. Patton.
Okay, for the record, it is 1:29. Started at 1:11, so that was 18 minutes. And Mr. Beach, whenever you're ready, you are on the clock.
Just a couple of questions here. I think we already clear on this, Mr. Patton, because you last worked for the department 24 years ago.
That's correct.
And you testified for us today that you authored what's been marked recommended here, plaintiff's exhibit 1, the revised plan for procurement from 2000.
That's incorrect.
All right.
I did not author it. I oversaw the writing of it and actually, my name is on it, but I did not author it.
All right. But you know everything that's in it, right?
That's correct.
Okay. I'd like to take a look here and read for me on page 18, that first paragraph that I highlighted.
Yes. There is legislative concern that granting the initial consideration to CMHs, especially PHP designation, could degenerate under political pressures into a perfunctory process that virtually guarantees approval for incumbent entities, even if they have serious deficiencies.
So back then, in 2000, there were concerns that there would be automatic or guaranteed approval for PIHPs, or there were concerns that there could be automatic approval for PIHPs that had serious deficiencies.
There was those possibilities, yes.
And it was anticipated that changes would be needed to the system if those type of things happened, right?
That's correct.
And from your testimony earlier, you're not testifying today that MDHHS isn't allowed to change the current system, correct?
That's correct.
Are you in any way disputing that MDHHS has the ability to change the number of regions in the state?
Under certain conditions, I'm not disputing that.
And it sounded from your testimony earlier that your major beef, I guess, in your current role is that you felt there was a lack of input or communication from MDHHS before the changes were made. Is that correct?
I think the term beef is probably the way you were presented. I think that my concern is that there has not been any kind of preliminary work with the system to bring the system along, you know, as was practiced in the revised plan for procurement.
And it is possible for the current regional entities to submit a bid under the current proposal if, under the current process, if they met the size of the region, correct?
I think it's more than the size of the region. I think that if they met the requirements, even the governance requirements,
Correct. If they meet all the requirements,
all of the requirements.
all the requirements. So it's just not limited to private entities. The current entities themselves, if they were reconstituted and meet all the requirements, could submit a bid, correct?
Repeat that question.
I think you testified earlier, and you can correct me if I'm wrong, but that the new procurement process was limited to private entities and that the current entities are being excluded. However, if the current entities meet all the
Please repeat
requirements.
that. I don't recall saying that. Would you
Sorry,
repeat that?
If you, okay,
Yeah.
let me ask my question
Yeah,
then?
please.
Okay.
Yeah.
We'll strike that
Start over again.
Yeah,
please.
I understood where
that
you were
was a
going.
bit compound.
Mhm.
Okay. I think you testified earlier, correct, that the current PIHPs are being excluded under the current procurement process or the ongoing procurement process.
Procurement, requirements, correct.
But it's true that the PIHP entities that currently exist, if they reconstituted themselves or underwent a reorganization, could submit bids so long as they met all the requirements, correct?
I'm not going to confirm that.
Why aren't you going to confirm that?
Because it's impractical.
So that's just your opinion.
You asked me and I've given it. Yes.
All right. All right. But they could, correct?
I think it's impractical. I think it's pretty impractical with the time period given for that.
All right.
But-
As a legal matter.
Well, perhaps if they hit 2 or 3 years, it probably could.
I don't have anything further.
Thank you very much. It's 1:35. That took 6 minutes. Mr. Marchand, any redirect?
Two short questions, Your Honor. Mr. Patton, to meet the requirements of the current RFP, would, the current request for proposal, would Kalamazoo and its partner organizations in SWIMBA have to disband SWIMBA and form a new regional entity?
Repeat that question.
To meet the requirements of the current request for proposal for the geographic mega regions, would Kalamazoo ISK and its partner CMHSPs within the Southwest Michigan Behavioral Health have to disband SWIMBA to form a new regional entity?
Yes.
Second, on page 18 of the request or the revised plan for procurement, that was exhibit 1. Did the state also, let me know once you're there.
Where are you here?
Page 18 where Mr. Beach had you read. So 18 at the bottom of the page.
Yes.
Yep, go 2 paragraphs down from where Mr. Beach had you read. The paragraph starts with, if the procurement.
Yes. If the procurement,
Yeah.
Yeah.
Did the state retain the right to sanction and terminate PIHPs that did not meet the standards?
yes.
In your 24 years of experience as CEO of Kalamazoo ISK, had there ever been any issues for you?
No.
Thank you.
Okay, thank you very much. Recross or not, Mr. Beach? You all set? Okay, great. Thank you. You may step down. Thank you very much, Mr. Patton.
Your Honor, do you guys plan to recall him at any time, or can you now sit in the gallery? Can we release him from this?
Oh, yeah. From the sequestration,
Correct.
any objection?
No, as long as he's not gonna be called again.
Okay, well, yes, as a matter of fact, if he remains in the courtroom, he will not be called again, I promise you.
Yeah.
We're not gonna start calling people in violation of the sequestration order.
Yeah.
Great. All right, that was 2 minutes for you, Mr. Marchand. So you're up to 20, you still have 55 left.
Okay.
Next witness, please.
Yep, this lane is gathering, is getting this Lindsay. I'll
That's
hand
fine.
Lindsay, Your Honor.
Okay, come on up, please. Apologize for the long walk. Please raise your right hand. You solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth. Thank you very much. Please have a seat. Before you get started with your testimony, would you please tell us your first and last names and spell your first and last names for the court reporter?
Like my chair.
Yeah, let's get you on the microphone.
Okay.
Okay, go ahead, please.
My first name is Sandra, Sandra. My last name is Lindsay, Lindsey.
Thank you very much, Ms. Lindsay, and you may proceed, Mr. Marchand.
Thank you. Thank you, Ms. Lindsay. Are you presently employed?
I am.
Where are you employed?
I'm employed at the Saginaw County Community Mental Health Authority.
And what is your role?
I'm the Chief Executive Officer
How long have you served as the CEO of Saginaw CMH?
since June of 2000.
Prior to that, where were you?
I was the Chief Executive Officer at the Oakland County Community Mental Health Department. It was not an authority. That was the last thing I did before I left there.
And can you tell me about Saginaw CMH?
Sure. Well, I guess I have to start with the county orientation, if that's all right, briefly.
Sure.
So Saginaw County is the smallest urban county in the state, according to the way the census defines things. We have about 187,000 plus persons that live within the county boundaries. We have 60,000 eligible Medicaid beneficiaries in Saginaw. I think at least 15,000 of those are from Medicaid expansion or Healthy Michigan. I say that because obviously Medicaid beneficiaries make up a large percentage of our population. Okay, so for the county of Saginaw, we are a county bound, a single county community mental health authority. Tell us something about it.
What role does it serve?
Okay.
As the county, as the geographic boundaries are limited to Saginaw County and you're the CMH authority, what is your function?
Well, I think we have the function to really operationalize and implement the service delivery of the Medicaid program, the specialty Medicaid program that, feeds down through our PIHP. We have that responsibility, but our scope is so much bigger than that because we really are the authority for behavioral health in our county. And not everyone is Medicaid eligible, right? So we try to consider our work, which is largely dominated, and we so appreciate the funding from Medicaid for those 65,000 people a month. The county is much bigger than that and has other issues. So we try to organize our service delivery in ways that make sense. On the Medicaid side, I don't know who's talked about this, but I mean, specialty benefit is a very complicated set of services that are organized under specific Medicaid authorities. And the way that the state historically has grown that benefit has been fabulous. It's been great for beneficiaries. So I sort of commend them on that. But to say that this is a simple benefit to manage, I think doesn't quite ring true for me. So it takes a fair amount of effort working with our PIHP to deliver those services, but we do so happily. We have about 350 staff of our own, and we do provide direct services ourselves, but we also have a large network of about 50 different providers that are under contract to us that have points of service inside Saginaw County. Those agencies may have multiple contracts because they may be providing multiple services. All right. I think if you asked our network, they would say that they feel tremendously supported by the Mental Health Authority. I want to speak specifically, I guess, unless you want to ask me differently, to the provisions of the current procurement, which would.
And we'll get there in a
All
second.
right, I'm sorry.
And so first though, are you familiar with, since you worked at Oakland CMH as a department and since June 2000 as CEO of Saginaw CMHA, are you familiar with the negotiation and formation of regional entities in the state?
Yes, very familiar.
Were you involved in the 2013-2014 application for participation process?
Yes, I was.
Can you tell me how that unfolded?
August 24th, 2012 was a pretty important day for the public mental health system. It was the day that Linda Zeller, the Director of Behavioral Health and Developmental Disabilities Administration, along with Steve Fenton, who I believe was the Medical Services Administrator at the time, called all of the CMHs to Lansing because she wanted, particularly Linda. Linda was largely the presenter. But anyway, called all of us to Lansing for a meeting that lasted for some time to talk about changes to the PIHP architecture that the state had imagined, as well as other ambitions that the state had. There was an outline to help people understand exactly what was going on. Some of the, what would I say, the tenets or the guide rails of how that new arrangement and consolidation of PIHPs would occur. I can recall most of them. There was supposed to be a nod to medical trading areas, meaning that we should be conscious of where our hospitals were because we have subpopulations that need medical care, and we are very active in local emergency rooms for crisis services. So I could understand that. There was a strong suggestion that there had to be contiguous geography. And because some of our CMH partners are multi-county CMHs, that as we move forward into new regional development, that no CMH would be cut in half. In other words, the geography of CMH would be kept whole. We were asked to give a nod to where the physical healthcare management of Medicaid was, in other words, looking at the regions. I'm not even sure that's the right word, but anyway, the regions of Medicaid health plans that were managing physical healthcare at the time. There may have been another, but I can't remember what it was.
Okay, when the department did this and brought you to Lansing in August of 2012, did the department dictate the number of regional entities to be formed?
Oh, no, not at all. In fact, right at the onset, right at the top of the meeting, Linda and Steve brought in 3 maps. They handed those out, 1, 2, and 3. They basically said quite candidly, we're not wedded to any of them.
Object to this hearsay.
This is an admission of a party opponent, Your Honor.
Oh,
There was a
who's
hearsay
speaking?
objection.
I'm sorry. Yeah, no, I heard that. Who's speaking?
Linda Zeller,
And her role, I know you explained it, but say
that's
again.
okay. She was at the time back in 2012. She was the director of the Behavioral Health and Developmental Disabilities Administration. She called the meeting.
Was that a party admission in this case
Yeah, well,
That's a department of MDHHS, correct?
Yes,
in 2012?
yes.
It's 2025.
okay, yeah, I'll overrule the objection. It sounds like it was a statement on behalf of somebody who was in a leadership position in MDHHS.
Correct. Are the maps at tab 5 in the binder in front of you, the 3 maps presented at that meeting?
Yes.
Did Linda Zeller or anyone else at MDHHS ever indicate that they would mandate those maps?
No.
Did Linda Zeller or anyone else at MDHHS ever indicate that they would unilaterally redraw regions or force Saginaw or any other CMH into a different region against their choice?
No.
I'd like to talk about the current RFP. Okay, by RFP, I mean request for proposal. Are you familiar with it?
Yeah, I'm familiar.
And you described the 2013-14 application for participation process. How does that differ from your experience with the current request for proposal?
Well, it was like night and day. The process in 2012 and 2013, which launched the new maps in January, I believe, of 2014, were a very collaborative process with the department. I don't think at the time I felt as though, I mean, I want to be clear, I don't think everybody was happy, right? The 18 PIHPs that were losing their autonomy.
Your Honor, we're talking about people that are unhappy, it's hearsay.
Right.
Unidentified individuals.
Yep, I'm with you. I sustain the objection. You can talk about your own perspective.
Okay, my
obviously. You don't have to-
perspective.
Just don't tell us what other people
I
thought,
was
'cause
not
we wouldn't know
happy. I was not happy at losing my
that.
autonomy.
Okay. There we go.
On the other hand, to be really candid, there were opportunities from joining with neighboring CMHs and through the provisions of the mental health code, creating a much larger PIHP.
Did you select the neighboring regions and counties with which you joined?
Personally,
Saginaw County.
I would say when I say collaborative, this is what I mean. I mean that my neighbors, my contiguous neighbors left that meeting. And within 2 days, we had decided who we wanted to partner with. and if you don't have any more money until your SSI payment next month, is so angry he destroys the home, does thousands of dollars of worth of damage, he needs to be taken care of and stabilized. So he, under our authorities, will be going into at least an emergency room for an evaluation for possible inpatient care. But the other 6 residents now have no place to live. The decision has to be made about the restoration, not only of the facility, but where are these people sleeping tonight? And that's not a Medicaid problem. That's a general fund problem. So that's an example about what CMHs in Michigan do across the state every day.
And will you have that same ability to react in real time if you don't hold the contract with the providers?
No,
How else do you expect Saginaw to be harmed?
Saginaw County Community Mental Health has exclusive trusted partnerships in Saginaw County. Those partnerships we've built over years. These are partnerships with 17 law enforcement agencies in Saginaw County, the Sheriff's Department, and campus police at both Saginaw Valley State University and Delta College, as an example of a partnership or set of partnerships. When things happen in the crisis space, we depend upon our colleagues in law enforcement to help. Whether those are pickup orders on involuntary court orders that have been violated, whether it is people that are encountered in the street or in homeless shelters where police are intervening, we meet our partners at the emergency room and we promise to try to discharge them from their custodial responsibility as soon as possible. These relationships will be shredded in this new arrangement because we will not be responsible for everybody. And yet, under the mental health code, we have very specific responsibilities as a safety net provider. All of our partners, whether it's law enforcement or homeless shelters or food pantries or veteran services, I could go on and name 20. They all want one thing.
Your Honor, objection, she's talking about.
Right.
All these parts.
Yeah, right. I'll sustain that. Right. I'm sorry. I don't mean to cut you off.
No,
This
no,
is-
I
this is-
understand. I
It's
understand.
an artificial construct, but you can't tell us what other people want.
What is the importance of these intergovernmental and interagency agreements for Saginaw?
I think I know there's an efficiency. I know that we will have reduced funding because if the PIHP is going to contract with others outside, which may or may not be our network, I would anticipate that there would be funding reduction. And yet I think the responsibilities for filling the spaces between network providers is really critical. This is a complicated benefit to manage. I'm not being critical of the benefit. I just think it's complicated. All right. And how it works is really dependent on the goodwill of everyone in the network who is serving any particular individual to make it work. Everything from scheduling the hours of service, in other words, when will a beneficiary receive service, to being responsive to the ever-changing needs of the people that we serve. We fill the space between those providers uniquely. We fill it with our human resources, meaning people that have expertise to go in and help providers, or with resources because we have to pay for broken windows and broken furniture in the example that I gave. You know, we have to put 5 people up in a hotel and move the staff of the home to that location because people have to have a place to live. And that's our responsibility.
And can you fill those gaps in the same way if the CMH is a network provider of a PIHP under the current proposed RFP?
I don't see how. If there's not a contract vehicle between the CMH and the provider, how do we move public money to help?
Does the current request for proposal have any impact on recipient rights?
Yes, it does.
Tell me about that impact.
Well, I mean, recipient rights under the mental health code is a very specified set of responsibilities. Recipient rights officers in the CMH space, not to be confused with state hospitals, they report directly to the executive director or the chief executive, which would be me. So in Saginaw's case, our recipient rights officer reports directly to me. And I don't know what you know, Judge, about rights, but basically anyone that's being served in the system can file a complaint if they're not happy about how they've been treated, if they've been respected, and a host of other protected rights under the Michigan Mental Health Code. When I don't hold the contract with our providers, I have lost my leverage to help the network be cooperative with recipient rights, to respond if there are substantiations with a plan of correction at a minimum. I've lost my leverage, which is, I think, a theme for me, as you said, you know, when I read the PIHP, what was the harm? It was the loss of autonomy. It was the loss of authority. I think those are the two things, because we know as CMHs what needs to be done in these spaces. All right. And we will not be able to do it, and certainly not in the same way, if we don't have those authorities.
Thank you, Ms. Lindsay.
Thank you, Ms. Marchand. It is 1:59. That was 20 minutes. So I now have you at 40 minutes down, 35 to go.
More questions?
You have.
Yeah.
I'm sorry.
Trying to escape. Be a lot easier to be a witness if you didn't have to be cross-examined.
Sorry about that.
Yeah, Mr. Beach, go ahead, please.
Thank you, Judge. Maybe, I'm sure you're aware that one of the reasons why MDHHS is seeking to implement these changes is to reduce the inefficiencies in the current system, correct?
I don't know that to be true.
Okay, do you have any reason to dispute that MDHHS is trying to reduce inefficiencies in the current system?
Well, I guess I'll take them at their word, but I don't know those inefficiencies.
Right, and I'm going to ask you some questions here specifically about your organization. I guess first, if we can, I know we've touched on it earlier, but what are managed care functions?
Well, there are several. I mean, I alluded to one in my earlier comments. One was this idea of network management. Customer services would be one. Claims payment would be one.
And another thing you do is you hold the provider contracts?
Yeah. Yeah, I'm sorry, I would have referenced that under network management.
And those are all the roles that PHP has in the system with regard to the managed care functions, correct?
Yes, that's in their contract. Mhm.
And currently your PIHP contracts with how many providers?
Well, there are 12 CMHs, and those CMHs all have contracts. They also manage a substance abuse network.
Does the PIHP also contract with any providers?
Yes,
How many providers do you?
I don't know. They are, I believe, all substance abuse providers. So
And do some of those providers also contract with the CMH SPSs?
I know in my case, and I can only speak for my case, there is one provider we have in common.
Wouldn't that seem inefficient to have providers contracting with both PIHP and the CMH SPSs?
I think there are some differences. I understand your point, but I don't agree. I think there are enough differences between the contracts that I don't think one contract would do.
All right, but as a general matter, having multiple contracts for the same type of services with two entities would be inefficient, correct?
Objection, Your Honor, that mischaracterizes Ms. Lindsay's testimony.
I'm asking.
Well, yeah, I'll let her answer. Right. I don't think that he's presented it in the form of argument. We'll give her a chance to respond as she sees fit.
I'm sorry, could you ask me the question again?
Sure. As a general matter, a provider holding multiple contracts with two separate entities for the same services would be inefficient, correct?
Provider, a PIHP, you mean?
No. A provider that's contracting with both the PIHP and the CMH SPS that in the same range, a provider contracting with both entities would be inefficient, right?
I'm not sure that I could agree with that on its face, potentially.
Okay.
Okay, potentially, but I don't, it's too simple a question.
I think we'll just figure it then potentially inefficient. If that existed, right?
Yes,
And you said that there is a provider that you're aware of, at least one, that's contracting with both.
Mhm.
And it's true that there are two individuals currently on the Saginaw PHP board or the CMH SPS board that's also on the Mid-State Health Network board.
yes, sir.
And that'd be Tracy Rackpaw and Joan Williams.
Correct.
Don't you think that's a conflict?
No,
How is that not a conflict for them to be on the board of both entities when one is supposed to be overseeing the other?
why don't you explain what you mean by conflict?
Do you understand what a conflict of interest is?
Yeah.
Okay. And you don't think it's a conflict of interest for an individual to be on the board of both entities, even though one entity is supposed to be overseeing the other entity?
Well, speaking to the conflict of interest piece, CMH board members, not the PIHP board, but CMH members are asked to disclose any conflict of interest every year. And I believe the same is asked of the Mid-State board members. So, conflict is real or perceived needs to be disclosed. The PIHP governing board is making decisions as requested by the CEO unique to their operations. CMH's downstream are very focused, not upstream, but downstream on what's happening with their CMHs inside their community.
But the PIHP is sending funding to the entities downstream, correct?
Yes,
So if you're on the board of the PIHP and you're authorizing funding to send to an entity that you're also on the board is, wouldn't that be a conflict of interest?
no, because they're not making decisions about how much money is going. At least in Mid-State, we have a subcapitated arrangement. So the actuary sets the rate, sends the money to Mid-State. Mid-State sends a subcapitation after they take off their administrative end to all the CMHs. No board member is making any decision about how much money anybody gets.
Are they making any decisions that?
Well, they're
affect the
approving a
oper-
budget. They're
Okay.
approving a budget.
Approving a budget,
Mhm.
and that's money.
Yes, it is.
And you understand that one of the goals for MDHHS with these new changes to the system is to eliminate conflict of interest, correct?
Yes, I've read that.
And you know that that's something that they've been told to do by the federal government, correct?
I don't know who told them. I don't know.
Right. I'm not going to deal with the objection. She said she doesn't know.
Hold on. Just one more question. The board for the PHP,
Mhm.
one of the other things that they would vote on would be the quality of the performance, right? You're saying that they do the budget, but they would also vote on the quality of performance of the CMH SPSs, correct?
I don't really understand your question because I don't understand that term of art.
Would the board of the PIHP evaluate the performance of The performance of I'm sorry, I always get it screwed up here, the CMHSPSs that they oversee.
I'm not familiar with that kind of a board action. The board would be recipients of quality indicators, right? Quality reports, right? And they would see those in aggregate. That is true. But they're not voting on the quality. They're overseeing an aggregate description of the performance of CMHs, usually quarterly.
All right, so if we call it, they're overseeing the performances of the CMHSPSs that they're overseeing, correct?
Within the context I just described, yes.
So wouldn't that be a conflict of interest for the person on the PIHP board to be voting on the quality of another organization that they're also on the board of?
Well, let me try to respond this way. When that information is in front of them, it's done. It's over. We're on to the next quarter. And it is a couple of markers about how a CMH may be performing for that period of time. So when you asked me your original question, I was really thrown because that's not how we think about quality for what we do.
Right.
And they don't make decisions about one community mental health board within the region versus another somehow suffering in terms of quality. I've never heard that kind of reference ever.
All right, I don't have it.
Very well. Thank you very much. It's 2:09, so that was 10 minutes.
Nothing further, Your Honor. Again, you're done for our purposes. Do you guys plan to, does the state plan to recall Ms. Lindsay for any purpose?
No.
Or think she's gonna go? Okay, so can she be released from? the-
Absolutely, absolutely. Right, you can stay and watch now. Thank you so much. Just for the record, Mr. Marchand, you have used 40 minutes, and Mr. Beach, you have used 16 minutes. Okay,
Your Honor,
Mr. Ryan.
plaintiff's call, Kristen Morningstar.
all right, thank you very much. Mr. Ryan has now taken over Mr. Trudell, so he will be the one asking questions on direct examination.
Thank you.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
Yeah.
Thank you very much. Please have a seat. Please tell us your first and last names and spell your first and last names for the court reporter.
Sure. Kristen Morningstar, Kristen, Morningstar, Morningstar.
Thank you very much, Ms. Morningstar. And whenever you're ready, Mr. Ryan, you may proceed.
Thank you. Good afternoon, Ms. Morningstar.
Good afternoon.
You are the Bureau Administrator for the Bureau of Specialty Behavioral Health Services within MDHHS, true?
True.
How long have you been with MDHHS?
Since 2012.
And you oversee the PIHP program, is that right?
I do.
You're familiar with the revised plan for procurement that we've talked about at length today?
Yes.
That is the latest version of the procurement that has been approved by CMS, true?
True.
The state has not received written permission from CMS to deviate from that revised plan for procurement, has it?
No.
And before issuing the RFP in question, MDHHS never issued an application for participation to a single CMHSP or regional entity, is
No.
that true? That's true?
That's true. Yeah.
The RFP doesn't give initial consideration to any CMHSP or regional entity, isn't that true?
Correct.
In fact, the RFP specifically precludes CMHSPs and regional entities from bidding, isn't that true?
No.
It's not true?
Are you saying as a matter, are you asking as a matter of law or as a practical matter, Mr. Ryan?
Let me read.
Right, because there's a big difference between the two, at least in my mind, from what I've heard so far. Yes, of course. Thank you. Very much.
Hand you what I'm gonna mark as proposed, evidentiary hearing exhibit A.
Would you mind calling it 9 because your book goes up to 8?
I would be happy to call it 9.
Then
Let's
it's
call
easier.
it proposed hearing exhibit 9.
Thank you. It's a lot easier for me to keep track of.
Yeah.
That way I
thank
can
you.
just put it in the book when we're finished.
Sure. Ms. Morningstar, or
Just real quick with the objection, if we could just have the, as far as it's coming in, never mind, I was looking to make sure there's a date and time stamp, just to make sure.
I'll lay the foundation for the exhibit.
Thank you.
That's fine. So to the extent I need to say it, it's not a trial, but plaintiff's proposed exhibit 9 is admitted. I'll make it part of the book that has 8 exhibits. So far, it'll be number 9. Thank you, Mr. Ryan. Go ahead. You may ask questions about this document. It's a 1-page document for the record.
Ms. Morningstar, the text message here indicates Kristen Jordan.
Yes,
Just for the benefit
Still
of the
me.
court,
Yeah.
that's your maiden, prior name, correct? Is that right?
Yes.
Okay. And these are text messages between you and Mr. Sedlock, is that right?
it doesn't have his name on here,
Do you
but
recognize
sure.
How do you spell his last name for the court reporter?
Sedlock.
Sedlock. Thank you very much.
And you indicate on May 23rd at 2:01 PM, you say, heads up, there's a new press release coming out this afternoon with some of the procurement criteria. Is that right?
Yes,
And he said, thanks for the heads up. And then he says, my read is regional entities aren't qualified bidders. Is this correct? And what's your answer?
yes,
MDHHS drew these new mega regions that are in the RFP. Is that correct?
correct.
Knowing full well that none of the regional entities would be able to bid. Isn't that true?
As they currently exist, yes,
In order to bid, the regional entity would have to disband entirely. All the counties that can form the new mega regions would have to get together and form a new regional entity. Isn't that true? Among other things.
I'm not quite sure how exactly they would do it, but
Do you have any reason to dispute that they'd have to disband
I
all of the
don't have
regional
a reason
entities
to
that currently
dispute that.
exist?
No.
The first public statement regarding competitive RFP was issued on February 28th of 2025, correct?
that sounds right.
It was a press release issued by MDHHS. Do you remember that?
Yes,
It was months before that that MDHHS reached the decision that they were going to engage in competitive procurement. Isn't that true?
months. I don't know the exact time, but I wouldn't say. I would have to look up the exact timeline.
Certainly before issuing a press release saying.
Definitely before issuing a press release. Yep.
The survey was issued on that same day, correct? The MDHHS issued a survey on the same day that it issued the press release saying it was going to move to competitive bidding. Isn't that true?
I would have to look at that.
Let me hand you a document. This was marked previously as Exhibit E to the preliminary injunction motion, Your Honor, so I'm not going to remark it again.
That's fine.
Is this the February 28th, 2025 announcement from MDHHS?
Yep.
And it says, among other things, MDHHS is seeking public input through an online survey as the department moves to a competitive procurement process for the state's prepaid inpatient health plan contracts. True?
Yes.
So the survey, the results came in over the next few months. True? The department then analyzed them. True?
Yes.
But given the timing, the survey results had nothing to do with the decision to move to competitive procurement, did it?
That's false.
How is it?
Oh,
that
I'm sorry.
survey results that
Let me
came
take
in
that back.
months later-
Hold on. Yeah.
Go ahead.
Yeah. So can you repeat the question again, though?
Yeah,
Please.
the survey results had nothing to do with the decision to move to competitive procurement because that was already made when the survey results came in, right?
The decision to move to competitive procurement. Correct.
Last question on the survey results. Are you familiar with the results?
Yes, it's been a bit, but
Less
sure.
than 1% of those survey results advocated for privatization. Isn't that true?
I,
Leading.
It's cross-examination.
Well, it's direct examination. Whoa. It's direct examination, but I think he's treating her as an adverse witness. I mean, she is an employee of the MDHHS, right? So, right.
The rules of evidence don't require me to ask that, but go
But
ahead.
no.
I
My
am
only
treating
point
her
is,
as an
right, you
adverse
have the right to treat her.
He never identified her as an adverse witness. I'm just putting an objection.
Okay. Right. I'll overrule the objection. I mean, it is standard operating procedure that if you call somebody from the other party, which you're entitled to do as an adverse witness, you're entitled to lead. Now, that means you can lead too, because it's your cross-examination. So you can effectively lead your own witness. That's what happens if you call an adverse witness.
Are you familiar with Senate Bills 597 and 598 from a few years ago that were proposed by Senator Shirkey?
yes,
One of the things that legislation would have done is authorized by statute consolidation of those 10 regions. Isn't that true?
Your Honor, I object. He's asking her to agree to the interpretation.
I don't know that yet. I could look at the bills, I guess, and try to draw my own conclusion about what they would do, but I'll see what she has to say about that. Thank you.
I'd be happy to show you the bills.
Right, I have read way too many bills in my time. Thank you. It's the advantage or disadvantage of being the chair of the legislative committee for Michigan judges for more than a decade. I've read more bills than I can count.
If you could flip to page 21, Ms.
perfect.
Morningstar.
Thank you.
Yep. This says, quote, "The department must consolidate the 10 regional specialty prepaid health plans existing on the date," correct?
Yes,
If you flip the page. Another thing that this bill would have done is authorize competitive procurement. Isn't that true?
yep,
It says, quote, "The department shall establish a competitive contract and procurement process that that outlines the eligibility requirement for entities to apply to operate as a specialty integrated plan," correct?
yes,
The bill failed, didn't it?
yes,
This bill didn't pass.
correct.
Correct. You state in your affidavit, quote, "Starting in fiscal year 2025, 5 of the 10 PIHPs elected not to sign a PIHP contract." That's what you said, correct?
Yes,
Isn't it in fact true that those 5 PIHPs signed a version of the fiscal year 2025 contract, sent it to MDHHS, and MDHHS refused to countersign it?
yes,
There was discussion this morning about whether regional entities and CMHSPs operating as PIHPs can operate into perpetuity. Do you hear that?
yes,
You're familiar with the mental health code and your role with the department, is that true?
yes,
And one of the provisions, section 232B, that's MCL 330.1232B, that discusses specialty prepaid health plans. That authorizes the department to issue sanctions up to and including termination of a PIHP contract if the PIHP is not involved with
I do not know the sections by heart, so, yeah, okay. Part 5,
5 and 6.
okay.
What that says is that contracts have to outline the sanctions that the department can take up to and including termination, correct?
Correct.
And then subsection 6 says before doing that, you have to issue notice, give them an opportunity for an administrative hearing following the Administrative Procedures Act, correct?
Yes,
The department has mechanisms by which they can sanction non-compliant PIHPs that would prevent them from operating into perpetuity without any sort of oversight by the department. Isn't that true?
yes.
Those are all the questions I have for Ms. Morningstar.
Thank you very much. It is now 2:23, so Mr. Ryan, you used 12 minutes. Cross-examination? Damage. And you may lead.
Thank you.
How about that?
I
That's
love
what
it.
happens when
I
they
love
call
it.
one
I
of,
know, right?
one of your witnesses.
Good afternoon, Ms. Morningstar. The plaintiffs have claimed that they will suffer irreparable harm if they are not able to participate under their current structure. You heard that today, correct?
Yes,
Okay. Would you agree that these providers have had notice of the procurement change and an opportunity to adapt their structure?
yes,
And in fact, earlier, Brother Counsel had submitted a text message that you had sent to a major player within the industry indicating as much, correct?
yes.
And this was back in May 23rd, I'm guessing 2024, 2025. And then, are you aware that there's a preliminary injunction filed in this case?
And-
And let me rephrase. Are you aware that there has been a motion filed by plaintiffs? They're asking your honor to immediately rule on because an emergency is at play.
Yes,
Okay. Do you know what that emergency is?
No.
Would you be surprised to hear that their emergency is that, well, the bids are closing soon and we're not going to qualify under the current procurement process?
that would be surprising.
Right, so it seems as though if it was such an emergency, why wasn't action, it seems that you would want, someone would want to take action before May 23rd? Correct, I mean, or at least RFP, when the public announcement was made, we testified about that.
Right.
Remember what day that was?
Uh,
Would you be surprised if it was in February 2025?
I would not be surprised, no.
Okay, and if this were such an emergency, don't you think something should have been filed sooner? Like if we needed to make sure to get these questions answered.
Yes.
Why wouldn't we have been hit with a preliminary injunction earlier than that?
Your Honor, I'm just going to object to the extent he's asking for.
Well, the last question calls for speculation, but everything else, believe it or not, was proper leading.
I didn't object.
Yeah, thank you. Right, I'll sustain the objection. Everything else can stand. Okay, go ahead. Right, you did a great job of leading until you actually started testifying yourself.
I mean, it's just at some point, it's like, I don't think you can control yourself. Sorry. Thank you, Your Honor.
I know it's great fun to lead.
It is my honor to do this today. We dream of this. So, take a step back here. Does the competitive solicitation process allow, the new process, does it allow any qualified entity, including current providers, to apply?
Yes, anyone that can meet the requirements.
There's nothing within his RFP that says that X entity cannot apply or Y entity cannot apply. You
Correct.
are prevented from applying.
Correct.
So to the extent that there's plaintiffs are concerned about the emergency here, there's a way they could fix their current problem, right? Would you agree with that?
I would.
And how would they do that?
They could restructure or figure out a way to meet the requirements of the RFP.
And you were here earlier today where you heard about in history where there have been changes to the amount of PIHPs in the regions, correct?
Yes.
So I'm gonna want to focus again just on the potential, the harm or the potential loss of a state contract. Let me ask you this. Would you agree that potential loss of a state contract by itself does not constitute irreparable harm?
I would agree that it does not.
I think I'll sustain that, although I know the answer to that question.
Thank you, Your Honor. Good to know. From your perspective, are the alleged harms to the current providers primarily financial or operational in nature?
I would be speculating, but it would be financial.
Wow, she set that objection up perfectly.
Let me ask you this way.
I'm not great at this.
Do you agree that the current PIHPs stand to make less money under the new structure?
If they were a successful bidder, they would make, I mean, if they were a successful bidder, they would get the capitation payments and they would be paid like any other PIHP would under this procurement.
And so as far as operational headaches from the PIHP and the CMHP's perspective, would you agree there would be somewhat of an operational obstacle to get over, correct? And that is just a change in their structure of their corporations, correct?
Correct.
And outside of that, have you seen any perceived hurdles that these PIHPs have to do in order to qualify as a bidder here?
No.
You were in the courtroom earlier today to hear Mr. Marchand's argument regarding PIHPs and CMHs. And there was a comment that he made about PIHPs and CMHs being one of the same. And it seemed to me, just from the general understanding of conflicts of interest, how is that possible? How is it possible to have a board member on an oversight function of a PIHP, but the same board member for the actual brick and mortar provider? Does that make sense?
Your Honor, I'm just gonna object. First of all, I think there was like 3 questions. Second of all, she's with MDHHS. She's not with PIHP. She's not with the CMH. I don't know how she can have any foundation.
I'll tell you what, ask that precise question and I'll overrule the objection and let you have it, because it seems to me if you can establish foundation that she provides oversight for PIHPs. I mean, she said she did.
Correct.
That's her job.
Correct.
So it seems to me that she ought to know
Absolutely.
whether there's a conflict of interest in that sort of relationship.
So let me back up so I have a little bit better foundation to Brother Counsel's point. One of the goals of switching to the competitive procurement process was to eliminate conflicts of interest, correct?
Correct.
And would you agree that if you have a member on one board who oversees another board, and that member is also on that same board as being overseen, it's going to be a conflict?
Correct.
Okay. I mean, could you imagine a situation, for example, we heard testimony about the fact that PIHPs do performance. They have a performance function and performance review over the CMHPs, correct?
Correct.
And if that performance review comes back bad, have you ever seen a corrective action plan put in place by PIHPs or anything?
Not that I'm aware of.
Have you seen anything that would restrict them from issuing a performance plan for the CMH?
No.
Okay, so it would be very weird, wouldn't it, if you were being evaluated by the same person. I mean, like the person you're overseeing is being evaluated by the person who's being overseen, right? It seems very kind of incestuous. Would you agree?
Yes.
That could be a conflict. Okay. And how does the current structure seek to rid of that conflict of interest?
Right, so there are requirements regarding board structure and those conflicts of interest that cannot occur as they do today.
Okay, I want to focus on the potential harms to MDHHS in the state if an injunction were to issue. We'll start there. If Your Honor were to issue an injunction today halting the solicitation process, would there be financial harm to MDHHS?
Yes, potentially.
What potential harm would that be?
Sure, so if we're delaying the implementation, we potentially would have to go through multiple transitions for these PIHPs because we have 5 of those PIHPs under contract only through the end of fiscal 26, so 9/30. So if there was a delay in being able to onboard new PIHPs, get them ready to serve, and ensure that they're meeting all their requirements, we could potentially have to transition more than one time. There's a lot that goes into that. We have to recertify rates. We have to get approval of those contracts from CMS. There are a lot of steps that take a long time. And we don't have a lot of time because of the contract situation.
Okay, and I want to elaborate on that. You don't have a lot of time for the contract because of the contract situation.
Sure.
What do you mean by that? Can you elaborate?
Sure. So those 5 contracts that they're still operating under fiscal 24, a clause in the 24 contract that expires. So we are unable to continue contracting with them after 9/30 of 26.
And if that happens, what would you do? What would MDHH's move be?
I mean, we are still reviewing what that looks like and what the transition looks like, but there would be a transition of those individuals. Those PIHPs would no longer be PIHPs.
Are you aware that a statement has been made that that 5 PIHPs are ready, willing, and able to continue under the current structure?
I am aware.
Okay. How would that work?
It wouldn't work. Right. So it's my understanding that we're required for various reasons to have a signed contract in place.
So in other words, if we go forward under their proposal, there wouldn't be a signed contract in place, correct?
Correct.
And the federal government doesn't like when the state agencies don't have contracts in place when they're dealing with their money, correct?
Right. That's not.
Foundation Judge.
Right, yeah, right. That's one of those things you can certainly argue, but I'll sustain the objection,
you.
right? You wouldn't know what the federal government's gonna do.
Okay, now, even if that were possible, and that would require you to then perhaps contract with each individual PIHP separately, correct?
Yes, we would have to issue new contracts.
And to do that, would you have to increase staff?
It would definitely take staff time to create a special contract
Well, it makes
for
sense
that.
because you have,
Right.
you have a contract to administer, right? And now you have 10 of them.
Objection, Your Honor. I think counsel's testifying.
How was that? That was a leading.
Wait, can I just ask you this question?
Absolutely.
Are all of your contracts 1-year contracts?
They
or
are.
Can you sign multi-year contracts?
No, they are 1-year contracts.
Is the reason for that the appropriation requirement, or is there something else to it that makes the contracts have to be only 1 year in duration?
That is a great question. The appropriations definitely play a part. I'm not quite sure if there's something else to it.
But it is the case that all of your contracts are 1 year.
Those are 1-year contracts, yes.
Okay, if a 1-year contract were to end and another contract were not in place, would there be lapse in coverage to beneficiaries?
Currently, there's not because of that continuation clause. That allows us to continue having them operate and fully function up to 2 years.
And if that goes away, what happens?
Then there is no contract.
And you'd have to go ahead and have direct contract with, solicit other direct contracts.
We would have to find another mechanism to flow the Medicaid dollars to those individuals.
What would be the effect on behavioral health service beneficiaries if the court were to delay the implementation of the new contracting system?
Sure, I think there would continue to be chaos and uncertainty in the system. I think that leads to, or we know that that leads to potential provider loss. If they don't know who their payer is going to be, they could potentially leave. These providers are critical to providing these services to the individuals that we serve. So we could experience provider loss. There could be loss in, the timing of plans of service. Just there could be impacts to individuals receiving services timely and appropriately.
And so there are risks that current providers could withdraw or even scale back services during a delay period,
Yes,
potentially. And just to reiterate, an injunction would cause a gap or lapse in coverage of services availability for beneficiaries?
Objection under being speculation.
I think she can answer that. I'll overrule it. Let's see what she says.
could you repeat the question?
Absolutely. Could an injunction create a gap or lapse in coverage or service availability for beneficiaries?
It could.
Okay. What happens to this population when there's a lapse in coverage?
Again, this population is very vulnerable. They can be difficult to serve. We need to make sure that they have continuous coverage, that they are getting to their appointments, that they are not experiencing a lapse in coverage.
Okay. Do you think that disruption would also pose risk to public safety?
Potentially.
And how? Potentially.
So we have cases where folks are not being monitored, not receiving services, not receiving their medications, which could potentially be an impact to public safety.
So in your view, the public interest would be better served by allowing the competitive procurement to proceed without interruption?
Yes,
Okay. And the state's interest would be better served by allowing the competitive procurement to proceed without interruption?
yes.
Have you heard any harm today that is going to be caused to the PIHP, the current PIHP providers outside of changing their structure?
No.
Okay. So in summary, granting the injunction would harm the state financially, correct?
Yes.
Operationally,
Yes.
while denying it would also help ensure stability and continuity for beneficiaries, right?
Correct.
You were asked about why MDHHS not signing a contract sent by the 5 PIHPs. Do you remember that?
Yes.
Is it true that MDHHS just did not accept their red lines?
We are unable to accept a redlined contract
And why is that?
because the contracts have to be signed in our system, in our electronic system. And we cannot accept red lines or modifications to the final contract.
Now, we heard testimony about the potential problems with this procurement process and selecting PIHPs and CMHs. Let's imagine a situation where Your Honor denies the injunction and we go forward and a contract is actually let to a qualifying bidder, the highest and best value bidder. Okay, you're in the same universe with me now, where after or you're in the operations of the actual contract itself.
Sure.
If in fact it's brought to MDHH's attention that there's significant harm being caused to beneficiaries, would MDHHS just ignore that?
Absolutely not.
What would you do?
We would evaluate, we would consider whatever evidence that they had. We would take a look at our policies, procedures, the contract.
In fact, you have DTMB, the Michigan Department of Technology Management and Budget, kind of holding your hand through this process, correct?
Yes,
And MDHHS, is your understanding, that's the state's procurement arm, right?
yes.
Okay. Are you aware that MDHHS has authority to take corrective action against individuals that they're contracting with?
Yes,
And so to the extent that there were, say, a conflict of interest, that could be something that perhaps DTMB could call out and say that, hey, you need to fix this, correct?
correct.
Can you tell me how this current system, not the current system, the new system is going to eliminate fragmentation?
Sure, there are additional considerations for oversight, reducing administrative burden in there, and just better care coordination. Also, there are along the administrative piece, simplifying the contractual process for providers, streamlining credentialing and things like that for providers to make it easier to provide those services, particularly for providers that provide those services in multiple areas of the state.
I'm sorry to interrupt, but what does
Yeah.
the word fragmentation mean to you? Because it's been used several times. When you talk about it in this universe, what does somebody mean when they talk about fragmentation? If you know, if you don't know, say you don't know.
Yeah, well, I will tell you how I took it. And to me, it means that it's non-continuous, that there are different obstacles that we could remove. Mhm.
Sorry, go ahead.
I don't have any further questions.
Thank you very much. That is 2:45 now, so that was 22 minutes. Any redirect, Mr. Ryan?
Yes, Your Honor.
Okay, go ahead.
Ms. Morningstar, you talked a little bit about some operational fixes that would have to be done at the regional entity level in order to be qualified to bid. Is that right?
Potentially.
They just have to kind of tweak their board composition and then be able to bid for an entire region. Is that right?
I'm not sure if that's all that would be involved.
Right. Actually, what would happen? Is that all of these regional entities that comprise this new mega central region would have to disband their regional entities. The officials from every single one of these counties would have to get together and agree to form a new regional entity that covers the entirety of the central region. Isn't that right?
Yes.
And if even one county, just one in the central region said, you know, we don't want to be a part of the central region, then nobody else in the entire region can bid. Isn't that true?
I'm not sure if that's true.
Well, they wouldn't be able to provide services throughout the entire region. Isn't that right? If one county held out,
Potentially.
if one county held out, they wouldn't be able to provide services. Isn't that true?
I'm not sure that could be true.
Was it your testimony that none of the PIHPs have ever issued corrective action plans to a CMHSP? Did I hear that right?
Did I say none? Did I
thought
say
you-
I'm not aware? I don't personally know.
Okay, you acknowledge that it is entirely possible that PIHPs have issued corrective action plans to their CMHSPs. Is it?
I do acknowledge that it's entirely possible.
Okay. The five PIHPs that we've referenced a number of times, that, with reference to the 2025 contract in the red lines, that's, Community Mental Health Partnership of Southeast Michigan, Lakeshore Regional Entity, Northern Michigan Regional Entity, North Care Network Mental Health Care Entity, and Region 10 PIHP. Is that correct?
Yes.
And attached to the filings, we attached an affidavit from every CEO of all five of those regions saying, we stand ready, willing, and able to continue beyond October 2026 when the transition language expires. You've seen those affidavits?
I haven't seen them, but I know that I'm aware of them. Yes.
Do you have any reason to dispute that those PIHPs would continue under the status quo if the court ordered it?
Can you ask the question again?
I'll ask a different question, actually. You referenced in your earlier testimony that you believe that a signed contract is required for every fiscal year.
Yes.
What says that? I'm not familiar with any statute or federal regulation or anything that says that. So I'm just curious.
Operationally, being able to provide the Medicaid dollars, we require a contract. We would not, under our procurement and purchasing rules, send those dollars out the door without a contract.
It's an MDHHS requirement.
It could be MDHHS, it could be DTMB. I'm not quite sure.
Well, let me ask you this. The transition language for those five PIHPs in essence says we're going to continue under the terms of the current contract for this 2-year transition period, right?
That's right.
And the state is apparently very concerned that what's going to happen at the end of the 2-year transition period, right?
We have a plan for what happens at the end of the transition period.
Right. That's this RFP. That's why you said that you're doing this
Right.
RFP, right?
Yes.
And you said there's a concern that at the end of this transition period, if this RFP doesn't go forward, if the court enjoins it, well, we're very concerned that people might not continue getting services. Isn't that what you said?
No, we would transition them to PIHPs that have signed contracts that are effective beyond 9/30/26. We would have to figure out a way to transition them to something else
For one of
in the
other-
interim.
for one of the other five is what you're.
Potentially, that's one
How
option.
would that work if the mental health code doesn't allow the regional entities to operate outside their region? It wouldn't work, would it?
I couldn't speak to that.
Let me ask you this. If it's such a concern, has the department, especially after receiving these affidavits, but even before, has the department approached the CEOs of any one of those five PIHPs and said, hey, look, we're trying to figure this thing out. Let's do a 1-page, 1-paragraph amendment, changing the transition date from September 30, 2026 to 2027 or 2028. Has the department approached any of them like that?
While we're litigating, no.
You were asked, in fact, by Judge Yates, why a 1-year contract, why it can't be longer, right? And the concept of appropriations was brought up.
Okay.
Don't the PIHP contracts have a clause in them saying that the funding is contingent upon appropriations?
Yes,
So in fact, there's nothing that would prohibit longer term contracts. Isn't that true?
I don't know that that's true.
Are you aware of anything that would prohibit a longer term contract?
Nothing is coming to mind.
That's all. Thank you.
Thank you. Sure. It's 2:52 now. And so that was another 7 minutes. After we finish this witness, we're going to take stock of where we are on the chess clocks. Cross-examination.
Ms. Morningstar, I'm just gonna follow up off of other counsel's questioning. regarding whether or not you're ready, willing, and able, or the PIHPs are ready, willing, and able, currently operating. Remember that?
Yes.
I'm gonna hand you something here.
The one thing I'd ask Mr. Damage, I'm sorry? No, not that. I need you to get on a microphone. I see that the court reporter's straining to hear you.
Absolutely.
Thank you.
Yeah, I hate the fact that the Court of Appeals microphones are wired in the way they are, but unless you're on a microphone, he can't hear you.
I'm gonna start this way. Are you aware that the federal government has regulations regarding state organization and general administration of behavioral health plans?
Yes.
Okay. What I have here is, I guess, yeah, just a snippet from.
What regulation is that even?
Hold on just a second. Do you all mean for this to be on the record? Because I can see the court reporter straining to figure out what in the world you're talking about and who's saying what.
We hear doesn't need to be on the record, though.
No, I got it.
Okay,
Okay.
all right. Now, Mr. Trudell, we're back on the record. Sorry, all that crosstalk was to try to make sense of something. So if you couldn't pick it up, that doesn't need to be on the record. Thank you. Go ahead.
Okay, thank you.
Back to the questioning regarding why the state or MDHHS would believe that signing a contract with these current PIHPs that are ready, willing, and able to operate on the current structure. Do you know whether or not CMS would permit it?
I don't believe so.
Okay. So
Your Honor, I didn't object to foundation because the question was, do you know whether they would do it? Which is a foundational question, but her answer was more than that. So she can't speak for CMS.
All right, right. I'll strike the answer. That's true. She cannot speak for any CMHs.
okay. Would you, in your position, would you ever enter into a contract that is not in accord with CMS's guidelines?
No.
All right, I just want to wrap up real quick for Judge Yates's purposes. As far as irreparable harm is concerned, from the state perspective, there's going to be, if in fact the injunction issues, there's going to be potentially duplicative services, correct?
Potentially.
There will be conflicts of interest, correct?
Yes.
There will be unsigned contracts, correct?
Yes.
And all that could lead to even more potential lawsuits, correct?
Correct.
Okay, no more questions, Your Honor.
All right, thank you very much. It is 2:55. And what I'd like to do, you may step down and you may stay here. It is Morningstar, so welcome back.
Yeah, actually, thank you for I should recall her.
Oh, okay, sorry. We're gonna have to excuse you. I apologize. All right, let's do this. Mr. Trudell, we're gonna go off the record for just a second because I'm concerned that we're gonna be all over the place trying to figure out where we are, whether we need a break and how much time everybody's used. So let me take care of this. Just give me a second here.
Okay.
All right, if you're keeping score at home, here's what my notes say. The plaintiff has used 59 minutes. That leaves you with 16 minutes to go. The defendants have used 41 minutes, and that leaves you with 34 minutes to go. Okay? Does anybody want to take a break now? We've been at this for a long time. Okay, let's take a break. We'll be back in 10 minutes. I'm sorry? Yeah, right. Hey, I'll tell you the story about when I was playing fifth board in high school chess and the other guy's chess You'll set up.
No, I tried to rotate this 45 degrees and realized it's like bolted.
Oh, no.
down. It's not gonna.
That thing will not be moved for centuries.
They'll throw the building down and that thing will still be.
Yeah. That's a fair estimate. I think Dan's had enough. Okay, whenever you're ready to go. I know Mr. Trudell wants to hear how this story ends, so. Waiting with bated breath. No doubt.
Yeah, we'll find out in 16 minutes, that's right.
I have to tell you one quick story. I had a trial I was running wait. Do you know Fred Boncher, right?
Yeah, yeah.
I mean, somebody told me he looks like Barney Rubble aging, which is actually. He is well known for going on and on and on and on and on and on. So anyway, the trial was running way behind and I was really frustrated. The jurors were frustrated. It's Friday afternoon. I said, all right, I can limit closings an hour aside and that's it. They've been living with this case too long already. So I said, I'll let you know at the 10-minute mark. So you'll be able to wrap up. So he gets going, he's going 78 RPMs. Can't follow him, going way too fast. So I tell him 10 minutes thinking, okay, now he'll stop, slow up and give a clean last 10 minutes. Nope, 3 times as fast. In the courtroom. He's going so fast I couldn't even understand what he was saying. It was phenomenal. And he won.
That's what I was just gonna ask.
He won. Well, he was representing the defendant. It was just no cause all the way around, so. Yep. All right. Mr. Trudell, if you dare, you ready?
All set, thanks.
Let me recap where we are. The plaintiff has 16 minutes left. The defendant has 34 minutes left. It's still the ball in your court, Mr. Marchand. Do you want to call anybody else or do you want to save some time for cross?
Yes, Your Honor.
Oh, welcome. Miss Wixon, nice to have you stand up. All right. Before you sit down, sir, I need to swear you in. Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth? Thank you. Thank you very much. Please take a seat. Before you get going, Ms. Wixon, let me ask a witness to tell us his first and last names and spell his first and last names for the court reporter.
First name is Joseph, Joseph. Last name Sedlock, Sedlock.
Oh, I'm sorry. I asked for the spelling of your name earlier and I should have just been patient and waited for you to tell me. Thank you very much, Mr. Sedlock, and Ms. Wixon, whenever you are ready, you may proceed.
Thank you. Thank you, Mr. Sedlock. Could you start by telling us where you're employed, please?
I'm employed at Midstate Health Network as its chief executive officer, and I've been in that role since November of 2015.
Okay, excellent. And can you briefly describe for me Midstate Health Network's mission, the counties it serves, and its role as a PIHP?
Sure. As you know, the Midstate Health Network is a PHP. We are responsible for the delivery of Medicaid specialty supports and services in a 21 county region. On the map that's exhibited there, it's the orange area in the Lower Peninsula that is our catchment area. We have 12 constituent CMHSPs as a part of that region and hundreds of other providers. Our sorry,
No,
got lost in the numbers.
Let's keep talking about the numbers. Can you explain to the court the total size of Midstate Health Network?
Sure. The number of Medicaid eligible individuals in the region varies between 450,000 and 500,000 individuals. Annually, we serve about 60 to 65,000 of those individuals that need specialty supports and services. We have a budget of about $906 million in total state administered funds. We have a staff of 60 individuals employed in our organization, and there are hundreds and hundreds and hundreds of others employed in various capacities in our provider network across the region.
And to be clear, are you currently, and by you, I mean Midstate Health Network, are you currently under contract with the state?
Yes, we have been under continuous contract with MDHHS or the state of Michigan since our founding in 2014. And we currently have an FY26 contract in place as well, which is the current year.
Okay, excellent. In your experience, can you explain what the key elements are to making a PIHP successful?
I think the key elements are really about partnership and the partnerships that we have created with our community mental health services programs, beginning with a commitment among all of the parties to service to beneficiaries first. A second commit, it's a very close second, a commitment to quality services and supports for Medicaid beneficiaries in the region and the communities that they operate in. Third, collaboration and being participants in decisions that affect those organizations and those communities and those beneficiaries. Fourth, accountability and stewardship for public resources. And fifth, probably compliance with regulatory requirements, contractual requirements, federal and state.
Let's talk about the compliance piece for a minute. Does Mid-State Health Network oversee compliance?
Yes, we do. We spend a lot of time and resources doing what we call provider performance monitoring against established standards. That applies both to our community mental health service participants and the providers in their networks, as well as the providers in the mid-state operated network itself.
And what happens if you find that something is not compliant or a provider is not compliant?
Well, it depends on the nature of the issue. If it's fraud, there's a different response than if there is non-compliance with a performance standard. Typically, there isn't fraud. Frankly, fraud is very rare in this area of operations. Mostly, there are if we find an issue of non-compliance, it's mostly addressed through a requirement that the entity develop a corrective action plan, submit that plan to us, and then we monitor that that plan is implemented through to completion.
Excellent. And in your years of experience and being the CEO of Mid-State Health Network, this monitoring of these corrective action plans, that's just something that is part of what you as a PIHP are responsible to do, correct?
Absolutely, yes.
All right. Let's talk just a minute about the board makeup of Mid-State Health Network. If there is a conflict that arises for one of your board members, is there a process to address that conflict?
Yes, there are conflicts. We're in a conflict right now. There are conflicts everywhere. The issue is how those conflicts are managed, right? And that they're equitably resolved. So there are established policies, procedures, and requirements that board members on the Mid-State Health Network or the PIHP board address their conflicts of interest publicly, transparently, and openly, and that the board together works to resolve those conflicts of interest, which is the same thing we do at the rest of the PIHP as well.
And is it fair to say that if a board member was individually conflicted out for some reason, that board member would recuse themselves?
Yes, or be recused by action of the rest of the board.
Okay, all right. Are you familiar with the current RFP issued by MDHHS for the PIHP contracts?
Yes, I am.
All right. When did you first become familiar with that?
And via a press release in late February of this year, 2025.
Okay, let's get right to it. When did you learn the final bid requirements for this new RFP process?
I believe it was the 4th or 5th of August of this year.
So up until August of this year, you did not know what the actual requirements for this new RFP were going to be specifically. Is that fair?
That is a fair statement, yes.
All right. After you learned of those requirements, did you believe that Mid-State Health Network as it exists today could bid successfully on this new RFP?
No, I did not.
If this RFP is implemented as written, can you explain the impact that will have on the beneficiaries that you serve?
I need to maybe tee up my answer just a little bit to say that we are responsible, and our community mental health services program participants are responsible for developing networks that support a continuum of care. Individuals with severe mental illness, with intellectual developmental disabilities, serious emotional disturbances, typically don't receive just one service. They receive multiple services over the course of a very long, in many cases, course of treatment. Those provider networks are what sustain local community CMHSPs and the beneficiaries that they're there to support. And this implementing the RFP, as stated, would first destroy those networks. That's a requirement. You can't delegate anything to any provider. And in the destruction of those networks, the individual beneficiaries no longer have access to the continuum of care that's required for their conditions. So my biggest worry is that those individuals will fall through the cracks that are created just by implementing this, and for no other reason.
So is what you're saying that this will harm the beneficiaries because they will not receive the same care that they have been receiving?
I'm saying that it will be so fragmented because of the requirement that the networks be dismantled. Maybe that's a temporary condition. Maybe it's permanent. I don't know. Assuming a new entity would come in, if awarded a contract, if the procurement proceeds, they would of course build the network and rebuild the network. What happens in the meantime is all of this stuff has to be dismantled so that somebody else can take it over. Pardon me. The second thing I want to address there, pardon me, is that the beneficiaries themselves rely on local access to services and supports. We can't do this from our office in Lansing. We can't do this from any place else in the region. It requires local control and local access points for individuals. The point I'm making is beneficiaries.
I think I'll allow it. Go ahead. Yeah, I mean, try to focus on the question she asked about what will happen if you're supplanted.
I'm trying to answer
Right,
that.
I know you are. I appreciate that. And I'm not criticizing your answer. The problem with the way that testimony comes in is that it's clunky. There has to be a question, then an answer, then a question and an answer. And particularly when people are as well informed as you are, the inclination is to provide as much information as you can, but it's fair to say that there has to be a question from time to time. So go ahead.
Thank you. I think I'm finished with that response.
Okay, thank you.
Okay, let's talk about the issue with continuity of care. And if this RFP proceeds, what do you have concerns around continuity of care for the beneficiaries?
Absolutely. I think I just described the genesis of that concern. Yes.
And if this RFP proceeds, will Mid-State Health Network have any reason to exist anymore?
No, we'll not. We will have to cease operations.
All right. So when you cease operations, isn't it true that years, a decade of institutional knowledge is just lost?
Not only that, institutional knowledge, the employees, the capacity, the trust, the relationships, the public trust that has been built over this last decade or 12 years or so, yes, that will all be lost.
And just to be clear, how do you see the exclusion of successful entities like Mid-State Health Network that's run, and administered up to $408 million for the last decade on an annual basis? How would removing that affect the trust and stability in the public mental health system?
From the question, counsel's testimony.
I think she was setting it up. Go ahead and finish the question.
Sure. How would excluding Mid-State Health Network and its operations, how would that affect the trust and stability in the public mental health system?
I think the first thing I'm deeply worried about in this respect is the providers that we have under contract to not only Mid-State itself, but to our CMHSPs going out of business, financial instability ensuing that would make it necessary for them to start considering whether they reduce, suspend, or terminate some, many, or all of their services or leave the market. I think that's the primary concern with providers. And the loss of it takes years to build capacity. It takes years to build infrastructure, and that goes away very, very quickly if this proceeds.
Okay, I have nothing further. Thank you.
Thank you very much. You are down to 4 minutes now. Thank you very much. Go ahead. Yes, Mr. Beach.
Thank you, Your Honor.
Yeah, you're welcome.
It's true that CMH SPSs are statutorily created, correct?
I missed the last part.
Are statutorily created,
CMHSPs? Yes,
right, and that's under the Michigan or under the Michigan Mental Health Code, correct?
yes,
And the CMH SPSs are required to provide specialty services to individuals under the mental health code, correct?
I'm not an expert on the mental health code, but that's my understanding of what's in it.
That's your understanding, right? And their responsibilities to provide those services wouldn't change at all under the current competitive procurement, correct?
No,
Okay. So there is a safety net for beneficiaries. They'll still get services from the CMH SPSs under the competitive, under the competitive procurement as it is laid out, correct?
I got lost in the question. Can you
Okay.
try me again?
All right. Those individuals, the beneficiaries, will still receive services from the CMH SPSs under the competitive procurement,
From
correct?
someone, yes,
All right.
CMHSPs and likely other providers, sure.
All right, let's talk about mid-state where you work. How many CMH SPSs do you currently oversee?
12,
Okay. And your board that oversees mid-state is made up entirely of members of those CMH SPSs. Isn't that correct?
yes,
Okay, in some cases too, right? Some of the CMH SPS is represented by 2 members of your board?
yes,
Okay,
not some of them, all of them.
okay, all of them. And it's true that you've delegated almost all of the current managed care functions from your PIHP to the 12 CMH SPSs, correct?
In large measure, that's correct. Some are partial delegations and some are full delegations, yes.
Doesn't that render your PIHP essentially just a shell at this point? You've delegated out all your responsibilities, right?
We are still responsible for every single thing that we delegate, and we have to oversee it and monitor it and correct any deficiencies that arise as a result.
Is that efficient to delegate all your managed care functions to the organizations that you supervise that are also your bosses on the board?
Yes,
Do you understand why MDHHS would have concerns with this, both as a conflict of interest and inefficiency with mid-state as you're running it?
I'm not concerned. I don't understand the department's positions on many things because they have not expressed those positions to me. But I understand the direction that they're going or they want to go with their public policy initiatives, yes.
And it's true that your PIHP was asked to do a financial audit.
Said you're a girl.
What the heck just happened? Hold on.
All right, we'll get him on.
Hold on, Mr. Trudell.
Hey, man.
Jeff, you're on video right now. You gotta turn off your video, bud. There you go. Apologies, we're back.
Okay, go ahead. Sorry about that.
Are we all set, Judge?
Yes, yes. Yeah, right. I was as startled as you were.
Who is this guy? I know. It's true you were asked by MDHHS to do a fiscal audit of the CMA or the CMH SPSs that you oversee?
A fiscal audit?
Yeah.
We do not provide fiscal audits of our CMHs. That is done by independent auditing firms.
Okay,
On the financial side, we do program audits all the time.
were you asked to do an audit by MDHHS?
We are required to do one by way of our contract. If there's a specific instance you're asking about, I'm unclear.
Okay, were you asked ever to do a financial audit?
Not to my-
Fiscal or financial audit?
not-
Are you
not-
just getting?
Not to my knowledge.
Okay. Did your vote? Did your board ever vote no to do an audit?
No.
Do you understand why MDHHS would see it as a conflict that the board that oversees you is made up of the entities that you've delegated all your responsibilities to?
I understand that's their position, yes.
I don't have any further questions.
Thank you very much. Very well. Okay, that was finished at the 3:30 mark. And I'm sorry, Mr. Sedlock, I don't mean to leave you sitting there. You may, I think, remain in the courtroom, although let's check on that.
We don't plan to recall him, Your Honor. Does the state plan to call Mr. Sedlock?
All right, and that was 6 minutes. So now, having finished with this witness, the plaintiff has 4 minutes and the defense has 29 minutes. So let me just see, and this is not on anybody's clock, whether the plaintiffs have anyone else to call.
We have one item to just simply introduce, and we'll reserve our 4 minutes for cross.
Okay.
We already have an authenticated affidavit for it. It's a recording of Director Patel at a private conference.
Oh, okay, that's fine. So, right.
Your Honor, would you like me to move for that admission?
Sure, why don't you come on up here to the lectern so we can get it.
Judge, I'm gonna object to this. We've never received a copy of it.
Well, I do have a copy.
Hold on, everybody needs to get on a mic, otherwise we're gonna have a problem. Okay, let's find out what it is first, because I have no idea how I should rule on an objection until I can figure out what we're doing.
Your Honor. So I do have copies for everyone. What I have are and permission to approach, Your Honor.
You may, let's make a record on this first. I understand, I can tell from the expressions at that table, they are
Yes.
at least upset and perhaps outraged that this is coming in.
Okay.
So-
So for the court's awareness, what I would like to move to admit is proposed exhibit 10. Proposed exhibit 10 is an approximately 26-minute recording of Michigan Department of Health and Human Services Director Elizabeth Hertel, which was made on September 17th, 2025, in which Director Hertel made substantive commentary on the pending RFP, which is the subject of this litigation. Included in the proposed exhibit, along with the approximately 26-minute recording, are an affidavit of Katherine Johnson, which lays the requisite foundation for admission, as well as a transcript of the recording for the party's use in listening to the audio recording. It would draw everyone's attention to specific portions of the recording, although the recording is 26 minutes. On page 18, lines 10 through 16 of the transcript, which are minutes 18:30.
I don't have this.
Permission.
asked you to strike that from the record.
Yeah.
Not agree to the admission.
Right, but look, the problem when I'm both trier of fact or whatever I am in an injunction hearing, and the presiding judge is I can't make a ruling on whether it's admissible or inadmissible without looking at it. I mean, you can rest assured, I'm not going to listen to it until we get this resolved, but at least I need to see what we're talking about here. Thank you.
That's the last document in the packet is the transcript. The second is the affidavit, and the envelope contains the flash drive.
Okay, now, let me ask a couple questions so I can try to figure out the provenance of this proposed exhibit.
Yes, Your Honor.
Was this surreptitiously recorded?
Yes, it was.
What kind of event was this, if it was an event at all?
It was a private event, specifically the 32nd Annual Recipients' Rights Conference in Kalamazoo, Michigan.
Was this an open conference or a closed conference? In other words, did you have to be invited or not?
You had to pay in order to attend, so you had to register and pay.
All right, and I presume that somebody who paid and attended recorded this.
Correct.
Okay.
And that's what's set forth, Your Honor, in the affidavit. And of course, we're moving under MRE 801 D2 as a statement of a party opponent.
And just to be clear about this, this is plainly not under oath, so,
That is correct, Your Honor.
okay. All right, now, I know it's awfully difficult to ask anybody else to react because you are obviously, from your expressions, as surprised about this as I am. Is there anything else you'd like to say before I let them respond?
I would, if the court has questions about the materiality of the statement, I'm happy to provide that information. But apart from that, I think the foundation is laid and the rules of evidence allow this to be entered for the court's use.
Okay, now, let them respond, and why don't you see the lectern and we'll
Thank
see
you, Your
what
Honor.
they have to say about this. Something tells me that they're not just going to agree to have this admitted.
Well, Judge, this is gamesmanship at its finest. Mr. Marchand brought over exhibits and handed them to me today. And he neglected to include this or even mention it. We've never heard about this before today. I would note that the affidavit that I would assume Mr. Marchand drafted is dated October 6th. So even if this is new, he sat on this for 3 days. And now he made no mention during break. I talked to his counsel here for Miller Johnson. She introduced herself, no mention of this coming. We've had no chance to listen to this. It's a flash drive. I mean, we've had no chance to review it. There's a transcript that Mr. Marchand probably ordered. Again, there's been ample opportunity. This is trial by ambush. If this was good faith, you know, he had plenty of opportunities to mention this. You know, this wasn't brought up at the status conference. It looks like the event was in September. Again, I don't know why Mr. Marchand wouldn't even include it in his plaintiff's exhibits either, if this was in any way good faith. So I would ask the court to strike the exhibit or not to admit the exhibit, to strike any testimony about it. Again, Mr. Marchand had ample opportunity to bring this to everyone's attention, even at the break, out in the hallway, and he neglected to mention any of this.
Well, let's talk about it in terms of its admissibility first, because surprise is something else that we're going to have to talk about. But as far as its admissibility, she is, as I understand, the director of the Michigan Department of Health and Human Services. So there's no question that she is allowed to speak for the Michigan Department of Health and Human Services. This isn't even a question of agency under the exception to the hearsay rule, right?
Correct.
Okay, so we don't have a hearsay problem because it would readily be admissible under Michigan Rule of Evidence 801 D 2 A. Statement offered against an opposing party and was made by the party in an individual or representative capacity. Or C, 801 D2C, was made by a person whom the party authorized to make a statement on the subject. Obviously, the head of the agency qualifies. All right. With regard to foundation, I presume what the affidavit says, although I haven't even had a chance to look at it, is that this person was present and recorded the statement. Is that accurate?
Correct, Your Honor.
All right. Relevance, I have no idea what's in this recording, but I'm betting that there's something significant said about the 2025 RFP and the decision to go to competitive procurement, right?
I would say the relevance goes to the department head admitting that recipient rights, there are problems with the recipient rights system that they have to address in their own RFP. And that's a problem that they need to deal with. After she said she cannot comment on the RFP, she then commented for 8 pages about the RFP. And so the reason for the contracting officer and our original request for Director Hertel at the status conference was the recording. As the court knows, we don't have discovery yet, so each side is bringing their exhibit as we come.
Right, and I tried to figure out how best to think about this, because obviously if this were a trial, it would necessarily not be admissible. Because there would have been a discovery process, this would have been requested, had it not been turned over, there's no way I would let it in. But as you point out, Mr. Marchand, we're proceeding at a rapid pace here, and everybody's trying to gin up whatever they can to bring to the hearing, because we haven't had discovery yet, right?
Correct.
Okay, now, Mr. Beach, I know that you are at the same disadvantage that I am, because I had no idea that this was coming. I should indicate for the record that we had a Zoom call, which was not recorded, but it took place within the last few days. And the purpose, since you all called the meeting, I didn't, was to try to figure out what the ground rules were going forward. And I'm sure I said something to the effect of, okay, if there's anything that's going to be a problem at the hearing, somebody let me know what's coming, okay? So I suspect, Mr. Beach, you would have imagined that that would have come out when we had our Zoom call.
My expectation, Your Honor, that
Right.
if there was audio, any type of recording or anything like that, I didn't think that we would have to be concerned. Plaintiff counsel also told us that, we talk about affidavits too, with regards to the other issues. So seemingly this should have come up in those conversations if this was something they were planning on doing. And based on the data on this, I think they've known about it for a while.
And it did come up. We disclosed to everyone, we had a statement of a party opponent to admit.
That was never disclosed.
That was part of the status conference and part of our request.
Okay, but well, hang on, just saying, in some ways, I'm a terrible audience for this, and I'll tell you why. I spent more than 20 years trying criminal cases in the federal system as both a prosecutor and a defense attorney. Guess how much discovery you get in the federal system in criminal cases? Zero. Every trial is entirely by ambush. And so I'm used to this sort of thing coming out. I mean, it was not uncommon for me to have a tape recording of my own client saying something that I didn't know existed. So I think I probably take much less umbrage than people ordinarily would on the bench, particularly if all they've done is civil practice, where you have to know the answer to every single question before you can even think about having a trial. So let me give you a chance to respond, Mr. Beach. I get it. You didn't know about this. I didn't know about this. I still don't even know what's in it because I have no idea.
That's part of the issue here. I don't know what it is either.
Your Honor, I'm just to make a record.
Okay, yeah, go ahead, Mr. Damage.
For the old methods, 901, the authenticating of identifying evidence. We have an affidavit, and the individual is not here to cross line with affidavits. We don't know about the veracity of what they're testifying. We talk about this problem.
Right.
Counsel, we're dealing with the same issue on the black,
Right. If it were a trial, this would be easy. There's no way it'd be coming in.
Judge, sorry, for interrupting, but I would note that the affidavit appears to be insufficient as well. It doesn't say when.
To establish foundation?
Yeah, it's got a date, doesn't say time it was made, the location.
All right.
It's very generalized. I would.
To the extent the state wants to call.
Okay, hold on. You can't talk over each other. You have to let him finish, and then Mr. Marchand, you'll get a chance, but poor Mr. Trudell can't take down two voices at the same time. Go ahead, Mr. Beach.
Thank you, Your Honor. And I would just note again, there is not I don't believe that this affidavit, even if the court would know it is sufficient to like any sort of proper foundation. Submitted today. Again, we would ask that if this person was present too, but we have no ability to cross examine. Even listen.
All right, Mr. Marchand, go ahead and respond.
If the state would like to examine the witness, she's available by Zoom and the court indicated Zoom testimony was an option for today. We can send her the link and she can testify.
Okay, I understand. All right, let's do this. Let's finish with everything else we have. I am in no position to rule on this right now. I haven't even had a chance to look at the transcript, much less read it, much less listen to the recording to see if I can even hear clearly what's on it. So let's keep going so we can try to get this finished. We still have 33 minutes of court time left and it's 3:45. I promise I will get back to this and revisit it. I'm not trying to avoid ruling on the admissibility of this, but I'm just not in a position to render a decision right now. Okay?
One point, Your Honor, is this 9 or 10? Did you introduce 9? It is 10. Okay.
Correct, yes. And I've indicated in my notes that it's plaintiff's proposed exhibit 10, and I know we had 9 come in, so I don't have a problem with any of that. Right. If the only problem we had was how to identify it, we'd be in great shape right now. Unfortunately, the problem goes a little deeper than that. Okay, do you have any other witnesses to call on behalf of the plaintiff? It'd be quite a trick to call somebody and examine them in 4 minutes, but I take it you're holding back.
We'll save our time for cross, Your Honor.
Okay, yeah, Irving Younger would appreciate this. He always says you should never ask more than 10 questions on cross-examination because no one knows how to cross and you're screwing up. You've probably seen the tapes too. I tend to disagree with him, but that's what he says. Okay, ball's in your court, Mr. Beach or Mr. Davis, whoever wants to go next.
Yes, sorry. We're going to recall, Ms. Morningstar.
Oh.
So ask that Ms. Gold be released, we don't plan to call.
Okay, well, they don't really have any time to do anything, even if they wanted to, so. Do you have any problem with releasing this other, Ms. Gold, is that her name? Go? Oh, Gove, Gove. Sorry, I'm trying to help Mr. Trudell there.
Southwest Pennsylvania, Pittsburgh accent.
Okay. Gove, Gove, Ms. Gove, we're excusing her. Yes?
Yes, sir.
Okay, Ms. Gove, wherever you are, you may stay or leave if you like. I guess, oh yeah, sequestered out in the hallway. All right, now, Mr. Damich, you want to call back now the witness who's already testified, who I guess is being sequestered again, right, Ms. Morningstar? Let's take a moment and get Ms. Morningstar back here.
Your Honor, we'll wait for her to come in. I just want to establish she's not allowed to lead her anymore, correct?
That's correct.
All right, thank you.
He was having fun doing it.
Sorry, Scott. I had to handcuff you, man.
Never a dull moment, Mr. Trudell. Trying to help you out with names here.
I appreciate it.
Thank you. I know this is exactly what you want to do. You get to take the witness stand again. Yeah. The record should reflect that Ms. Morningstar has re-entered the courtroom. She went back to being sequestered and now she is on the witness stand again. I will not swear her in again. She's already been sworn, so there's no reason to do that. And Mr. Damich, whenever you're ready, you may proceed. And now you're on direct examination, so no leading.
Thank you, Your Honor. I'll do my best to not lead. Hi, Ms. Morningstar. Welcome back. Are you familiar with whether or not CMHSPs are statutorily created under the Mental Health Code?
Yes.
And are you aware that CMHSPs are required to provide specialty services to individuals identified under the Mental Health Code?
Yes.
Will their responsibilities under the code change under the new competitive procurement?
The responsibilities under the mental health code do not change.
And so what will change for the for the CMHSPs?
So the CMHSPs will retain their statutory authority as the safety net provider system. What would change for CMHs that have managed care functions delegated to them currently by the CMH, that would change.
Okay, so is it fair to say that the only thing that would change is there'd be no managed care? There'd be no longer managed care from,
Correct.
and
Can I ask you a question before we move on from this point? Because I want to make sure that I understand how this would go. So a long, long time ago, when there were 49 or something of these CMHSPs, and there was not statutory authority yet to set up these PIHPs, that was a world that existed before the amendments to the statute. Is that what we'd be going back to now?
No.
In the short term until you can get new PIHPs in place or whatever's going to take the place of PIHPs?
Yeah, that could be an option if we're delayed and couldn't stand up the new PIHPs. The way that we have the timeline laid out currently is that we would be able to stand up the new PIHPs through the procurement. We would be able to award and stand them up ready to operate 10/1 of 26. So for fiscal 27.
So
If there were delays, that could be an option.
So
to go
be
back.
clear,
Mhm.
under the 2025 RFP, the structure will remain the same as it was before the 2025 RFPs, but there'll be new names on the uniforms of the PIHPs.
You got it. Yep, they will still be PIHPs, but they will not be required to be regional entities formed by a CMH any longer.
Okay, thank you. And I'm sorry to interrupt, but I just wanted to make sure I understood.
Yep.
so, I want to go back, and discuss the reasons why MDHHS switched to the competitive procurement process. Was this change made to improve efficiency?
Yes.
How would it improve efficiency?
So we are requiring administrative efficiencies in terms of more streamlined contracting practices. There would be fewer PIHPs. So there would be fewer contractual arrangements that would need to happen. We would have additional oversight. And there would be additional transparency through our contract with the PIHPs. And there would be more accountability as well.
Oh, yeah.
Thank you.
Thank you.
Was the change made to improve accountability?
Yes.
So accountability was an issue, is currently an issue under the current program, correct?
Yes.
And can you elaborate on that?
Sure. So if we're talking about the structural accountability where we have CMHs forming PIHPs, that there's that conflict there, that we have conflict of interest issues in terms of, we're out of compliance with federal rules, and we've had a significant amount of pushback on our home and community-based services rules around conflict-free access and planning. Those are just a couple of examples.
you think of any other problems with the prior system that the MDHHS is looking to change? Or remedy, not change, but remedy.
Nothing's coming to mind right now. Yeah.
Um, How will oversight improve under the new procurement process for services reform?
Sure. In terms of oversight, we will have an ability to require our PIHPs to provide. I'm sorry, I'm losing my train of thought here.
It's a long day.
It is. Can you repeat the question?
How will oversight improve under the 2025 RFP system?
Thank you. So oversight will improve because we will have an ability to hold our PIHPs accountable in terms of I'm so sorry. I cannot.
Let me ask you this.
Yeah.
Let me ask you this.
Mhm.
Will, under the new structure, will the PIHPs be subject to the Freedom of Information Act?
Yes, they will.
Are they right now?
Yes, they are.
Oh, they are right now.
Yes,
So if they're subject to the Freedom of Information Act, is it fair to say the public could then request information on the performance of the contract?
absolutely.
And also, is there a mechanism that if there's underperformance in the contract that MDHHS and or DTMB could go ahead and address that situation?
Absolutely.
And how, are you familiar with how they would do that?
Sure. There are ways we could put them on corrective action plans. We could, if there are multiple PIHPs in a region, there could be a reassignment of the beneficiaries. So the payer would be reassigned potentially. There are additional remedies that we would have for accountability.
Under the current system, were there problems with cap rates at all with the current PIHPs? Are there any disagreements between PIHPs and MDHHS over cap rates?
Oh, I would say there were disagreements.
And how do those disagreements usually end?
Well, we take into consideration the feedback that we get from PIHPs. Ultimately, at the end of the day, we're required to have actuarially sound rates and provide appropriate rates in terms of the CMS requirements for Medicaid rates.
Times with CMS is asked you though, it makes sure the rates are appropriate for individual PIHPs.
Have there been times that CMS has asked us to do that? I think we do that on our own. We take the initiative to do that.
Have you done that before?
Yes.
And have you recognized any issues there during your time span working with MDHHS?
We have modified rates.
And
Yes.
so when you, have there been instances where the PIHPs had just simply said, we're not going to honor that rate?
Have they said we're not going to honor that rate? They have refused or could you restate the question?
Yeah, let me think about a different way to phrase this.
Okay.
Let's see, you know what, I'm just gonna withdraw that line of questioning.
Move on to the next, one last thing I wanted to clarify. I just want to be abundantly clear because it is and I understand this is me talking, but it is one of the most vulnerable portions of our society. Are the beneficiaries going to lose service under the new plan?
Will beneficiaries lose service under the new plan? No.
And the safety net for those beneficiaries will still be there under the new plan, correct?
Absolutely.
No more questions.
Okay, let me just get the timing down on this. Hold on, sorry, 3:15. So that was 14 minutes. And before you start your cross-examination, Mr. Ryan, this is on nobody's tab. I'd just like to ask you a couple questions to understand this. You said your role is to oversee PIHPs, right?
Yes.
Have you personally talked regularly with these CEOs who've come in to testify today?
Yes.
So is part of your role dealing directly with the heads of these PIHPs?
Yes.
Have you voiced concerns to them about the sorts of conflicts of interest you're describing today?
Yes.
Okay, thank you. Now you may go ahead, Mr. Wright. Thank you. Well, right, no, I didn't take that, right.
All right.
I promise I'm not going to cheat you out of a single minute. Go ahead.
Ms. Morningstar, under the RFP, the recipient rights function goes to the new PIHP, isn't that true?
So I would say that any functions afforded to CMHs under statutory authority will remain with CMHs.
That's not what the RFP says. It says the recipient rights function goes to the new PIHP, doesn't it?
I would have to review that.
You've read the RFP, correct?
I've read the RFP.
All right. Can we agree that by statute, under the mental health code, the recipient rights function belongs exclusively to the CMHSPs? We show you MCL 330.1206, and I apologize for being so close. I only have one copy.
That's okay.
This says the purpose of a community mental health service.
Your Honor, for the same reason I wasn't able to ask questions about the document, I was previously questioned with the federal regulations. I asked that we provide a copy as well before we ask questions more with this regarding the same.
Are you just reading a statute?
It's a statute.
Okay, yeah, one of the statutes we've been talking about all day. Which one is it?
MCL 330.1206.
Okay.
Your Honor, just fundamental fairness, we weren't able to then use.
I'm happy to show it.
Wait, but I think, look, stop for a second. At the very most, I think he is simply trying to refresh recollection. You can refresh recollection by showing the witness a piece of apple pie. It doesn't have to be a document. If a baseball bat triggers their memory, then you can do that. Now, what I'm going to insist you do though, Mr. Ryan, is after she looks at it, have her give it back to you, then ask her if her memory is refreshed. Then let's see if we can have her testify from her refreshed recollection. In other words, the document is not being used for any evidentiary purpose.
Thank you, Your Honor.
Okay, thank you very much.
This Morningstar, I apologize. This is not apple pie.
Right, sorry, it's boring. Okay, set it aside when you're done or give it back
Sure.
to Mr. Ryan. Now, go ahead and ask your question.
Back to the microphone for Mr. Trudeau. Ms. Morningstar, isn't it true that the recipient rights function is delegated exclusively by statute to community mental health services programs?
Yes.
And are you familiar with the provision of the mental health code that says each community mental health services program and each licensed hospital shall establish an office of recipient rights subordinate only to the executive director or hospital director?
Yes.
And your testimony here today is you don't know whether the current RFP redelegates that function to the new PIHP?
I would have to look at the exact language. I don't recall.
No more questions.
Thank you very much. And for what it's worth, the RFP of 2025 is in evidence for all purposes. So if you want to read it to me when you make your argument at the end to tell me what it says, we can all do that. It is an exhibit.
That was my intention.
That's what I figured. All right, any redirect examination? Okay, thank you very much. Now, let me recompute the time here. And the plaintiff is now down to 2 minutes. And the defendants are now down to 15 minutes. So I think you may step down.
Okay,
I hasten to add that I'm not sure if we're finished with you yet until somebody says so, but I think we are.
Judge, we're going to be finished with Morningstar.
Oh, so you can stay if you want.
Unless plaintiffs would like to call her again, which.
They only have 2 minutes.
For some
Do a lot in
reason.
2 minutes.
Yeah, they're gonna use their last 2 minutes to get one more question.
Okay, now, any other witnesses for the defense?
Defense has no additional.
Oh, marvelous. All right, let's do this then. Let's take 5 minutes and let you gather your thoughts. Then I'll come back and hear whatever you want to tell me. We have to clear the building before 5 o'clock, so I'll give you each 20 minutes if you want. I feel like I've heard a great deal, but still, it's always effective to have everybody's summaries of what you think I heard today. So take a few minutes, gather your thoughts, and then we'll come back and do this, okay?
Thank you.
Thank you very much. Appreciate it. Dan, we'll get the building closed down by 5, I promise. All right, let's get Mr. Trudell back up here. Thanks for your patience, Mr. Trudell.
Not a problem.
You've been a trooper today.
I appreciate it.
All right, let's see if we can get everybody in place. And then what I'm going to do is I'm going to allow each side approximately 20 minutes. I'm not going to run a stopwatch on this, but I promised our head of security that I'd have the building cleared by 5 o'clock today, and I don't see any reason we can't get there now. Okay. Mr. Trudell, you ready?
All set.
Back on the record. Now, it appears that Mr. Ryan is going to be making the argument, and I want to hear everything you want to say, but there is a very fundamental question, the $64,000 question that my senior research attorney and I were discussing. Write your order. What do you want your order to say if you win declaratory relief? Because I have to confess that I'm a little bit confused about whether you want me to declare the 2025 RFP out of compliance with state law, or that's okay. Take your time. I mean, this is one of those great moot court questions we used to ask law students, and we'd say, okay, you win. What does your order say? They get stumped by that question. And I think, okay, this is odd. So you can think about it for a minute, but tell me what, if you win declaratory relief, what do you want the order to say?
That the RFP by number violates the mental health code.
Okay. Now, what happens next then? The RFP is effectively withdrawn by court order, right?
Yes.
Okay.
And what happens next is, I don't think that this court is in a position, nor do I think it would be appropriate for the court to then dictate what MDHHS's next move is.
No, I don't intend to
MDHHS
do
could
that.
come back to the regional entities. They could go back to the drawing board and reconfigure the RFP in a way that actually complies with the mental health code. They could do a number of things. They could actually, what they should do and what they tried to do in the first place, they could go to the legislature if they think that the regions should be consolidated and that the open procurement should happen.
Okay.
They can go to the legislature and ask for that.
All right. So just to be clear then, you want a declaration that the RFP of 2025 is incompatible with Michigan law, correct?
Yes.
And therefore cannot be used as the basis for forming contracts with PIHPs.
Yes.
Let me just write that down. So. Do you also want some sort of declaration about the reduction from 10 to 3 regions?
Well, I think that's part of the RFP.
I understand, but I'm going to write, if I'm going to write an order in your favor, I want it to be as clear as possible.
Yeah, I think that the mental health code prohibits MDHHS from unilaterally reducing the regions from 10 to 3.
All right. That helps a lot. Now, I can confess to you and to the other side that I'm strongly disinclined to grant injunctive relief because all those admonitions in Davis about not enjoining state officials, I think, come into play here. But if I do this right, which I intend to do, by Monday or Tuesday, you're going to get an opinion on declaratory relief, which will say, in effect, what an injunction would have said anyway.
Yeah, functionally the same.
Right.
Yes.
It's just the idea of enjoining the head of a state agency when I haven't even given them any opportunity to come into compliance with the law seems to arrogate more power to myself than I ought to.
Understood. Not to make the timing any worse, but I was reminded before I stepped up here that I'm told Monday is a holiday. I don't know if it's a court holiday or not, but I'm told it's a holiday. So
is it?
And Monday is also the bid deadline.
Indigenous Peoples' Day, but I don't know if it's a court holiday for state court.
I have no idea.
Just thought I'd throw that out there to make your life a little bit more difficult.
No, that's good. Well, actually, I mean, I'm gonna be here working all day on Monday anyway. It doesn't really matter. I didn't even know it was a holiday, but, right, I get more work done on the weekends than I do during the weeks because I don't get emails or phone calls or anything.
Sounds
Okay,
familiar.
I appreciate that. All right. So just to be clear about that then, one more thing. What is the current deadline for submission of bids?
Monday.
Monday? Oh, geez.
At 11:58.
Right. For some reason, I saw that because there's some reference in it where anything that comes in at 11:51 is late, which amused me.
Sounds like a court deadline, right?
It's a random time. Yeah, we actually had somebody file a brief requesting oral argument, and it didn't get filed till 12:01, so it was late, and so they didn't get oral argument because they failed a timely We gave them oral argument anyway. Okay, Mr. Ryan, I'm sorry. So in essence, then, in the event that I rule against you, there is absolutely nothing your clients can do. They can't disband and reform. I mean, there's no time for any of this. Okay, I got it. I understand.
I mean, and I will address this as part of my closing.
Yeah,
but,
go ahead. Right. I'm sorry.
No, it's okay. I appreciate the question and I'll expound on it. in a
Okay,
minute.
go ahead. Now I promise I'm going to interrupt you infrequently. But I just want to know what you need me to say if you
Yeah,
would.
I appreciate that. So one of the questions that Your Honor asked is, you know, what would happen next if you declare that the RFP is void, as being in violation of state law. And I want to come back to a point that was addressed in some of the testimony because I think it's important, but we did spend a ton of time on it. A few years ago, there was an effort by MDHHS to try to pass legislation that would have consolidated the regions and opened up the PIHP system to competitive procurement. The attempts failed. And instead of going back to the legislature, going back to the drawing board, working through the bipartisan process, MDHHS said, we're issuing an RFP. We're going to do it anyway. We're going to consolidate the regions. We're going to open it up to competitive procurement.
Well, I
And
will
it's-
say this,
it's-
I never want to read too much into a bill not becoming law. I mean, there are so many bills that do so many things. I mean, every time there are bills drop to change the no-fault system, and I don't read that as preclusive just because it didn't get through the legislature.
It's not necessarily that it's preclusive. It just evidences the fact that these are changes that need to happen at the legislative level. It can't happen by executive, not to be overly dramatic, executive fiat, right? The executive branch has to work within the confines of the mental health code and the directives that in the rubric that's set forth by the legislature.
Follow this though, because let's say that the federal government pulls the exemption. Now, they almost have to act unilaterally, don't they? They can't sit around and wait for the legislature to do something 6 months or a year or 2 years later. I mean, if that exemption goes away, then they have to go to a competitive procurement system, right?
If the exemption goes away, then absent change, it risks the same thing that this RFP risks, by the way, by deviating from the current sole source procurement waiver. It risks the federal funding, the federal match,
Right.
going away. So what would happen? They'd go to the legislature and say, hey, we're going to lose like $10 billion if we don't come together and
I
get
get
a
it.
fix. And all of a sudden changes will happen, right?
You have more confidence about the legislative process.
Well, I think you dangle $10 billion and people
No,
are willing
I
to bend.
understand. I get it. But there's never any guarantee that some bill's going to get through.
Of course not. And frankly, we see that, right? We saw it, bills not getting through. But the point is, if the executive agency tries to do it through the legislative process, because that's what it takes, amending the mental health code, and it fails, they can't just go around the legislature, do an end run and say, we're going to do it anyway. That's not the way our system works. And the courts are there to stop exactly that. We see it on the national level all the time. Our position is very simple. The state lacks the authority to just dismantle the community-based mental health system through an RFP that by design excludes the very entities that the legislature said have the power to serve as the PIHPs. So I want to,
We
if I-
do know, though, that the CMHs are not going to change, right?
that is not true. And that is a point that I'm just trying to make just a few minutes ago, and I'm happy to address that.
Yeah, because the CMHSPs, at least as far as I could tell from the testimony of Ms. Morningstar, will continue to exist. Now, we can talk about whether their authorization changes, whether their obligation changes, whether their mandate changes, but they will continue to exist, right?
The CMHSPs may continue to exist.
Right.
The regional entities, which is 3 of the 6 plaintiffs that are here, will
No,
not.
I get that, right?
Yes.
That was the next point I was going to make.
Right.
What happens if I allow them to do this is the PIHPs essentially evaporate. They don't have to evaporate, but they have no reason for being anymore, right?
So I want to make a little distinction. Everybody uses the terms regional entities and PIHPs interchangeably.
Right.
Because all of the regional entities are PIHPs, but not all of the PIHPs are regional entities, if that makes sense, because Wayne, Oakland, and Macomb are PIHP. So I just want to draw the distinction. The regional entities will disappear. The current PIHPs will disappear.
Right. And I think one of the CEOs was very clear about that. They essentially are shuttered if this RFP goes through.
And that's one of the CEOs of the 7 non-CMHSP PIHPs.
Right.
But they're all in the same boat, right? The regional entities that operate as PIHPs are gone. And they can say, well, they could just, reconfigure and it's, first of all, there's the practical problem, right? Getting every one of those county governments to agree to come together is not a thing, but let me.
Right. Even if they had started back in February when there was first some talk about this, it would have been almost impossible to essentially disband and reconfigure, because who even knew what the regions were going to be?
Nobody.
Right.
And,
So you
and
couldn't
by the
even
way,
start until you knew what the regions were going to be.
correct. And when you talk about disbanding and reforming and well, it's, let me make a point. Three of these plaintiffs are regional entities under the mental health code. This is a statute we've been talking about a lot, but we haven't talked about this provision. It's MCL 330.1204 b, and this is subpart 3. A regional entity established under this section is a public governmental entity separate from the county authority or organization that establishes it.
Give me
So
that
this-
statutory side again. I want to catch up with you.
Yeah, it's 1204 subpart, the little b.
And then what subsection?
And then it's subsection 3.
A regional entity established under this section is a public governmental entity separate from the county authority or organization that establishes.
And I bring this up for a reason. These are entities that can sue, they can be sued. They're functioning entities with a legal existence. So to say, well, you can just disband the entity and create a new one. They're gone. That legal entity that has rights given to it by the legislature is gone.
I
So
agree.
this idea that the counties, even if they come together to form a new regional entity, that's all well and good, but it doesn't cure the problem that the plaintiffs who are regional entities are done.
Right.
So, I mean, if I could summarize the likelihood of success argument in the most simple way possible, it's this. The statute, the mental health code, says regional entities have the power to contract to be the PIHPs for their designated service area. The RFP says they can't. They don't have the ability, as the state defines power, their briefing says, well, power means the ability. Kristen Morningstar admitted, none of those regional entities have the ability. So although the legislature says you have the power to contract to be the PIHP for your region, the RFP says no. And they can't do that.
You mean that in a practical sense, because what their coverage areas are no longer coterminous with any region. Yes?
Well, that is true, but I think it's more than just a practical sense, right? I mean, they can't bid because they can't serve an entire region.
Right.
Yeah, so they have lost the power.
Right. I think we're saying the same thing in slightly different words, but I mean, the difficulty is that even if they went from 10 regions to 10 regions, but they redrew the lines of all the regions, you'd be in exactly the same pickle that you're in now, right?
Pretty much. It would be the problem, the practical problem of trying to get all the people to agree would be lessened because you'd have to bring less people together. But yes, functionally, yes, they'd be out of existence.
So the reduction from 10 to 3 isn't what's really damaging. What's damaging is changing the region so that no existing PIHP serves the entire new region.
Yes, the fact that it goes from 10 to 3 exacerbates the problem.
Sure.
But
Well, right, it
yes.
squeezes out
Yes.
anybody who might want to try to reconstitute. I mean, it now creates an opportunity for only 3 entities to be PIHPs, right?
Yes. So I want to highlight a couple of pieces of Ms. Morningstar's testimony. She not only admitted that the regional entities can't bid. She admitted MDHHS never issued an application for participation to any of the CMHSPs or the PIHPs. And she admitted, very importantly, that the revised plan for procurement, which requires them to do that, issue the application for participation, has never been, there's been no deviations approved by CMS, which means this RFP, if it goes forward, it's violating the current CMS approved procurement plan. That's a problem. That's a big problem. We heard testimony from Sandra, Lindsay, that shows when the state restructured these regions in 2013 and 2014, MDHHS didn't dictate the regional boundaries. Local communities, the various counties and the CMHs negotiated, came together, chose to band together with their chosen partners and form these regions. And that's codified in the statute that allows the regional entities to exist in the first place. The statute says they may form regional entities. It doesn't say they have to. It doesn't say they must form regional entities as dictated by MDHHS. It allows them the discretion to do it or not.
Do the survey results matter at all? The fact that, for example, only 1% of the survey respondents said that this was a good idea?
Well, I mean,
I don't think it
candidly,
matters as a matter of law, but I was really struck by that testimony.
well, the reality is, I mean, there was the affidavit that said, that referenced the survey results as being kind of part of the reason why they were moving to this system. But they announced the system was going to be privatized and was going to go to this competitive model before the RFP, before the survey was even issued, let alone the results being
They were
back.
contemporaneously issued, I think, right?
Yeah, it was February 28th. They said, we're doing 2 things. Number 1, we're issuing a survey. And number 2, we're issuing it for competitive bidding. And then they come and they say, hey, we issued competitive bidding because of the survey.
That is remarkable.
Yeah.
Ready, shoot, aim.
Fire, aim. So I want to address very briefly to the appropriations bill, which I think is now 48 hours old. Because it does address this argument of who can bid, who can line up to the starting gate, as Mr. Marchand says. In the section of that legislation that discusses MDHHS, the first thing it does is it appropriates MDHHS about $30 billion, that's with a B, $30 billion. And then it says, and I'll quote, "The department shall use the funds appropriated in Part 1 to support a system of comprehensive community mental health services under the full authority and responsibility of local CMHSPs or PIHPs in accordance with the Mental Health Code." That legislation then defines what is a PIHP. And it says it's, quote, "a regional entity or a specialty prepaid inpatient health plan," which again, the legislation defines regional entity by reference to 1204B, which we've talked about at length today. And it defines specialty prepaid health plan as the entities described in 1232B. That is the CMHSPs. Nowhere in any of of the definitions of the legislation does it reference any type of entity other than a CMHSP or a regional entity? Not a nonprofit, not the University of Michigan or some other public university.
So
Not in there.
Is
And
it
that's
your
48
view
hours
that
ago.
now, if they go forward, I mean, when they put out the RFP, they didn't know what the appropriation bill was going to say, but now they'd be out of compliance with the appropriation bill that the governor just
I
signed?
think that the language has been in every appropriations bill for a long time. So I
I
don't think this is
doubt
new.
that. But I mean, there'd be nothing wrong with using an appropriations bill to try to clean up this mess, but nobody made any effort to do that.
I'm not sure I would say nobody made an effort to do it, but it certainly didn't get passed if there was an effort, if there was a lobbying
No,
effort.
I'm talking about in the immediate past.
Yes, correct. It didn't get put in the appropriations bill, but yeah, you're right. They could have. They could have said as part of the appropriations bill, we're authorizing the reduction, we're authorizing privatization.
Could have done anything you wanted.
Could have done any of that. Never happened. In fact, the legislation doubled down on the fact that PIHPs refers to one of two types of entities, not the people contemplated by the RFP. There was a question about recipient rights that came up in this concept, and I think it's an important one I want to just touch on a minute. The statute that I asked Ms. Morningstar about, MCL 330.1206, says the purpose of a community mental health services program shall be to provide a comprehensive array of mental health services appropriate to conditions of individuals who are located within its geographic service area, regardless of an individual's ability to pay. The array of mental health services shall include, at a minimum, all of the following. Subpart E, little e, says recipient rights services. The recipient rights portion of the mental health code, which is codified at MCL 330.1755, subpart 1, says each community mental health services program and each licensed hospital shall establish an office of recipient rights subordinate only to the executive director. Here's why this is important. Exhibit B to the complaint was the RFP.
Yeah, right.
And it says on page 6 of 8, which discusses definition under managed care functions. It says managed care functions are administrative activities the contractor performs to fulfill the requirements of 42 CFR 438 and the terms of the contract. Managed care functions include, and one of them is recipient rights. Upholding enrollee rights and protections is the exact language that is used. And then it says, quote, the managed care functions listed above cannot be delegated to a contracted provider entity. The state released their question and answers on the RFP. We've attached these. These are exhibit 13 to the response to the MSD. They're long. It's a long spreadsheet, but line 96 says CMHSPs are network providers as defined by the amended Schedule G definitions / explanation of terms. You cannot possibly reconcile this RFP with the mental health code. Mental health code says CMHSPs get the recipient rights function. RFP says the opposite. All of this has gone to the likelihood of success on the merits.
Right, and I think, as I indicated, I'm far more inclined to grant declaratory relief than injunctive relief. So it's fair to focus on that rather than the separate requirements for injunctive relief.
I will briefly address those though, if Your Honor wants.
I wouldn't worry about it because, as I
Okay,
said, you're
fair
going to get a
enough.
very timely declaratory judgment if you win, but not an injunction. Now, I'm glad we made the record today because if for some reason there's non-compliance, then I don't have to hold a hearing before I convert the declaratory judgment to an injunction.
Yeah.
And if they don't comply, I'm certainly willing to do that, but I want to give them the first shot at it. And you've made, I think, more than an adequate showing of likelihood of irreparable harm.
Okay.
And I think the problems resulting from this will ripple all the way through the system. Now, The question, though, comes back to what Mr. Marchand said in his brief, where he said it's not only unwise, but unlawful. I mean, I can't prohibit this if it's just unwise.
Agreed.
You will
The
see
court,
very clearly, in
Yes.
my opinion, I think this is a mistake,
the court.
but I don't know whether it's illegal.
Right. I agree. The court functions not to second guess policy.
Right.
Right. And frankly, we're not here saying that MDHHS doesn't have discretion to make changes or to adapt to changing conditions or anything like that. What we're saying is they have to do it within the confines of the mental health code.
Agreed.
Right.
Okay, you and
And
I are
so-
on the same page then.
Yes,
Right.
yes.
You have a much higher hurdle to overcome than you would if you were just trying to get injunctive relief, and we could all agree that it's a violation of the law.
Understood. So but again, the point being, the mental health code very clearly says a couple things. Number one, being recipient rights that I just covered. I'm not going to reiterate it. And number two, being we have the right, we have the power to contract to be the PIHPs for our designated service area. And the RFP says the opposite. So for all those reasons, we'd ask that the declaratory relief be granted. If your honor has any other questions, I'm happy to answer.
I don't. Thank you. This has been a very educational day for me. Thank you.
Appreciate your time. Thank you.
Okay, Ms. Service, are you going to handle this? All right. So I don't know whether it's good news or bad news for you that I think this is terribly unwise, but quite probably legal.
Guess what I would say to that is respectfully, it's not in the court's purview to decide whether this is wise.
Oh, I know. I have been a judge a long time, and I know that I don't get to decide public policy. That's not my role.
That's right. And the legislature clearly delegated that responsibility to DHHS. So whether any of us in this room agree with the policy changes or not, it doesn't make them illegal.
That's why we have elections. If somebody wants to get elected and make policy changes, that's what you have to do.
Right. And in this case, I guess I'll start with try to work my way backwards from some of the things Mr. Ryan said, just because they're fresh on my mind. So in this question about the recipient rights process. So I was just looking at a copy of that Q&A document that Mr. Ryan referenced, and I was looking at a number 78 in that document, question number 78, and it asked about recipient rights, and it said something like the process or the procedure will not change. So at any rate, maybe there's some confusion there, but DHHS is telling me that that process will not change.
I'm not so much worried about that. Talk to me about the language in the appropriations bill, which I haven't even looked at yet. I mean, it's hot off the presses, but trust me, I will look at it before I finish this opinion.
Yeah, so that language, I think, as Mr. Ryan said, has been in the appropriations bills for a long time.
That doesn't mean we can just ignore it.
Well, the appropriations bill lasts only until September 30th of 2026. And so at the current time when
So it doesn't affect the RFP of 2025 because that's contracting for the next.
Correct. Currently, DHHS has chosen for PIHPs to be CMHs or CMHSP regional
I
entities.
see. So what you're going to tell me is you're in compliance for this budget year.
In compliance currently. Now,
And nothing will happen that will knock you out of compliance.
I
this
don't
budget.
expect anything to, right? Yeah, I mean, that's the final budget.
I
My
get it.
understanding is the
No, that's
governor's now signed it.
Yep.
So, and what that language is it's basically like a description of PIHP. And it says a PIHP is a regional entity or CMHSP, and it talks about those two mental health code statutes. But that is the case now. DHHS has using their power to choose those types of entities up until now.
I see. I hadn't thought about that. You're right, because the RFP doesn't deal with this fiscal year. It's the next
Correct.
fiscal year.
Correct.
So you might be out of compliance, but somebody has to bring a lawsuit a year from now, and by then it's too late. The horse has left the barn.
If the contracts next year for fiscal year 2027, so starting October 1st, are something other than those, then I guess that's some separate lawsuit, another discussion, but that would be only if that language is in place in the next fiscal year. Right now.
I understand, right. I mean,
Yeah.
they could go back and rewrite it to clean it up, to conform to what you've done. I get it.
Sure.
I understand.
Sure. So I also want to quickly mention the survey results. this piece on, only 1% supported it. What the survey said is 1% supported privatization. And as I mentioned earlier, this is not privatization.
I get it, right, because public entities can participate,
Correct, correct,
not-for-profits,
correct.
universities, et cetera.
And then there was some discussion from Mr. Ryan on, CMS approval, and DHHS is moving forward with this RFP without having any approval from CMS. And to this, I would say almost the same thing as I argued just a minute ago with the appropriations. These contracts have not yet been signed. And so as the testimony from Ms. Morningstar showed, CMS is aware of this process. And if and when there's something that DHHS needs to do to, at some point before the contracts are signed, become into compliance, they will. But it's like a chicken or the egg problem. And of course, this lawsuit and plaintiffs are asking to hold the whole thing up at any rate. So, if there's anything that needs to be done before the contracts are signed, DHHS will certainly do it.
Can we at least agree as a practical matter, there's nothing they can do as long as these regions are upheld to become legitimate bidders who could be given a contract?
They meaning
Any of the existing PIHPs. I mean,
Right.
It's way too late now. I mean, if in fact the deadline's 11:50 on Monday morning, but I mean, even if they had known months ago, it would have been almost impossible for them to come into compliance. They would have had to disband and reform and get approval everywhere.
I guess I would say this, I can't speak to their business requirements or their board requirements or when they can call a special meeting or when they can get on the phone and agree to band together. I can say that I understand the frustration with that. But the other piece of this too is these contracts, as Ms. Morningstar testified, are 1-year contracts. And so, if it takes
They could
several
go
months.
dormant for a year and
Sure.
then bid.
Sure, they could. They absolutely could.
But I mean, by then there are replacements in place, right?
Ye-
So there's an incumbent that they'd have to essentially knock off.
Sure, but there's no preclusion against them from doing
I
that.
get it. I get it.
And also, I know Mr. Ryan said, well, the, current regional entities are like demolished or whatever adjective he used, but really, the regional entities can still exist and they can do all the other functions under 1204B. What they wouldn't be able to do if they don't meet the minimum bidding requirements is one of those many functions under 1204B, which is to contract as a PIHP.
Right, but I mean, you heard the testimony today, and they all say that this is curtains for them if they lose this lawsuit.
Yep.
I mean, you can't very well tell all of your contacts and your contractual partners and your employees, hang around for a year, maybe we'll get the contract next year.
Yeah, I did hear that. And the other thing I heard too was a concern about contracting with multiple entities or having this provider network that could fall. But one benefit of the RFP is that there's one entity, the PIHP, who would be in charge of contracting for the region. And so regardless of what happens with the CMHSPs, if they form regional entities or whatever they do, there is one entity in charge of that contracting. And that was particularly, I heard Ms. Lindsay say, we so appreciate the Medicaid funding that flows through. To that, I would say, but the end of the sentence would be, but, there's concerns of a loss of federal Medicaid funding that Ms. Morningstar testified to. And, if they so appreciate the Medicaid funding flowing through, there's also that consideration there that under the current system, there's a federal government with oversight who appears not to be happy with DHHS and says they're not in compliance, and that could risk a loss of federal Medicaid funding, which would harm everybody in this room.
Well, right. I mean, that's why I say, for example, if the federal government pulls the exemption, you almost have to be given some latitude to operate unilaterally to try to address the problem. I mean, you got to bring yourself into compliance with what the federal government wants you to do, or you risk an enormous loss of money.
Enormous loss of
That
money,
hasn't
yeah.
happened as far as the record indicates. The exemption remains in place. And so at least in theory, we're a sole source state rather than a competitive procurement state as we sit here today, right?
So as we sit here today, that is the waiver that the federal government gave based on that plan for procurement that we've been talking about today, where DHHS chose to go with the single source. That's the federal government approved that plan. But so DHHS is now choosing to do something different. And if they have to come into compliance with anything with the federal government, I'm sure the federal government would be more than happy to do that, given their concerns in the first place. The other thing I heard today, and maybe this has validity, but is concerns from the PIHPs and the CMHSPs of a lack of communication, or a feeling like they weren't being heard, or people weren't working with them and the state was just making decisions. So I hear what they're saying, but I also, as a practical matter, when, this is a very legal argument, I would say that there's no legal statute that requires communication, requires working together of that nature.
Right, no, I get it, that whatever was done in 2013 into 2014 was a decision of all the affected parties to have a conversation and try to reach a solution. That doesn't dictate that you have to repeat history, right?
Correct, especially right now when half of the PIHPs are not under contract and they've sued the state in several lawsuits. So you can understand kind of the culture and maybe why that was done. But again, what we're talking about here is the law. And while this is maybe a policy discussion, it doesn't drive what the law actually requires. The other thing I wanted to highlight from the testimony is in Mr. Patton's testimony, he talked about significant thought that DHHS put into, when he was working there, put into, what should we do with this system? And that kind of mirrors the situation that DHHS finds themselves in now, where they've put significant thought into the system and they made a choice to do it this way, just as when Mr. Patton was at DHHS, they put thought into it and made a choice to do it a different way. So with the elements of an injunction, I mean, of course, as the court's well aware and mentioned at the beginning of this hearing, injunctions are an extraordinarily rare.
I don't think you have to worry about me granting an injunction. I have become very, very leery about injunctions against state officials. I just don't think it's a good idea. I've never had an experience where I issued a declaratory judgment and the state refused to follow it. Now, I have the record if I need to do that, but if I rule in their favor, it's going to take the form of a declaratory judgment, not an injunctive order. You would have to essentially refuse to comply in order for me to issue an injunction.
Sure, that makes sense. So I guess then in closing, to go back to the merits then, because that's really clearly where this.
I mean, I presume as you stand here today, you are acknowledging on behalf of the department that if I issue a declaratory judgment, you will follow it. Unless and until it's reversed on appeal.
But I would have no expectation that any state agency would just flagrantly violate a court order.
In my experience, every single time I've issued an order.
Yeah. So on the merits then, again, I just want to highlight, when we look at the history of all of these statutes combined, and we look at the fact that the statutes that gave broad authority to DHHS to administer the program, to contract, things of that nature, and of course, to choose who PIHPs are. And then we look at the two mental health code statutes that plaintiffs rely on, which came later in time, don't expressly do anything to take away that power of DHHS to choose the PIHPs. There's really no choice but to rule in favor of the defendants for this motion. So thank you.
All right. Thank you very much, Ms. Service. Thank you, everybody. It's been a long day, but I've learned a great deal and I really appreciate the quality of the work by everybody. You've given me a great deal to think about, and I promise you will get an answer no later than Tuesday. I'm frustrated by the fact that we have a deadline at 11:50 on Monday. But I suppose if I issue a declaratory judgment saying that the RFP of 2025 can't stand, no bid's going to be awarded between 11:50 on Monday and whenever the opinion comes out. I don't even know if that'd be remotely possible to do that.
My understanding is there's a whole process
Sure.
that has to go through, so I would
right.
not expect.
Yep. Okay. All right. Well, thank you very much. Mr. Trudell, thank you for hanging in there with us today. We are finished.
No problem.
Thank you all for staying on time today so that we can hopefully close the building within the next 5 or 10 minutes.